Good morning. Do we think it's going to be Donna today? I think it will be Donna today. Good morning, Ani. Aw, I'm sorry that your back is bothering you. Hopefully, we'll have another amazing performance from the defense team. Good morning, baby. Good morning, Uncle Roger. Good morning, Graham. So I put out apple cider vinegar last night. Do you think there's any fruit flies in there? Not a one. And there's still like 3 in this freaking room. They're starting their own live stream. They have revolted against me. And I'm just going to give them the house. It's yours. Enjoy your world. All right. Good morning, Sherry and Harry E. and Germain and Matt. Good morning to Harvey, the fruit fly that's buzzing around my face. He wants to fight. Everybody said you were aggressive, Harvey, and we believe it. All right. So court was fun yesterday. Look at this picture. Oh no, my head, my earphone. Look at the picture that they have up of Donna. I can't. Good evening, LP Travels. What will catch the fruit flies? Good morning, Kelly Lynn. The apple cider vinegar that I thought would catch them last night, that literally they're just like mocking me by not getting in it. I don't appreciate. Good morning, PLN 315. I am happy you are here. Very, very happy. Was it too loud? Too soft? I literally had the volume boosted 1,000% for the courtroom. And then I put my stuff on, and I will either forget to turn it down or I'll remember to turn it down and forget to turn it back up. So while we're talking about this, yeah, so sorry. Sherry, that's my fault. I'm still trying to get my life together. I'm trying to get my life together. Good morning, the good Donna. Okay. I had somebody come here from another live stream because they're like, we're getting yelled at for making fun of Horseface Fulford. And I'm like, oh, well, feel free. You're welcome here. You are completely welcome here. Good morning, Gila. There is not even any fruit or food or anything in this room. That's why I'm just like, I ended up pouring muriatic acid down my bathtub drain yesterday and putting a mug over it. And I'm thinking maybe they're coming from there. My bathtub is like woefully clogged upstairs. I've tried everything myself, of course, because I am that type of person that just wants to do it myself because, one, I'm impatient, mostly because I'm impatient. Oh, a spooky baby at the window. Good morning, Denise and Becky and Stacy and Debbie. Sorry, I was so busy looking that up, but I did see it, Debbie, and I appreciate it. And I sent her the stuff. I sent her the stuff that I was finding on Gutterman or Gutterson. Okay. See, I'm leaving the spiders in the house. I'm hoping they would catch the fruit flies. Oh, good morning, Declan or Declan. Um, okay. Yeah, I was doing my PI search for Patty. Good morning, Christopher. Oh, good morning, afternoon sunshines from Paris. How delightful. How much Donna wishes that she was in Paris. Okay, so let me kick down the volume. If I don't put it back up, somebody remind me because I'm just half alive. Okay, so let's watch the short that I put up yesterday. Do you like today's thumbnail? Just Donna is an absolute banana. Okay, so I was watching. Good morning, Skimble Shanks. Nice to see you. Uh, I was watching Patty's Playhouse live yesterday, and she actually put up a defense witness list. This is literally like what I was going to the docket for when I went there yesterday. I spent like freaking like a billion hours on the docket, and did I find the defense witness list? No, I probably just skimmed right past it. Um, Okie dokie. So there's Marisol Descalzo, and she was looking, Patty was looking at what flights were coming in today. Because, yeah, did you literally hear Judge Everett yesterday? He's like, just so you know, I want everybody to be here at 8:30 and we're gonna start at 8:45. And Zellman's like, um, our girl's flight, our witness's flight doesn't get here till 10. And we'll try to have her here as soon as possible. You had a long weekend. You had an entire extra day to get your shit together, defense team. I cannot. Maybe I just didn't make the holes big enough. They're bigger now. I've just decided they're gonna take the house. I'm giving it to them. Good morning, Warflare, and good morning, Victoria in Miami. Who can it be now? So anyway, Patty was looking up flights, and there's a flight apparently that comes in to Tallahassee from Miami at 10 a.m. tomorrow morning, or to this morning now. Good morning, Nenya Business. So I don't understand how they can be so woefully prepared. Good morning, Isle of Shoals. Apparently, I think it was the second seat when Rashbaum was the lawyer. The lawyer Daddy Rashbaum. I think it was that girl. So, okay. Debbie says there's a new theory from someone on Reddit that Wendy first went to the crime scene around 10 and then went back to ABC claiming that she went from Dan's immediately to ABC's. Interesting. Well, I was kind of wondering about the timeline as well because I have from the TPD that Isom sent somebody to Wendy's. I don't know why I wanted to call her Becky. To Wendy's house to do surveillance on her house as soon as they got to Dan's. Well, or pretty soon after they got to Dan. Um, Good morning, Bling Chick, and good morning, Colleen. Okay, so the owl. All right, this is the owl connection, and I don't know. There's people in the chat that know more than me. I have admittedly not looked into the owl thing too much. Hi, A innuendo or I innuendo. You know who you are. um, so I know that Luis took a picture of an owl when he was up in Tallahassee. Okay. And immediately when he did that, apparently Katie saw it. Katie called Sigfredo and was like, have him take that shit down. You can't be posting stuff from Tallahassee where you're up there to do this murder. So he takes it down. Oh, that's interesting, Debbie. So he takes it down and then Wendy wears this owl shirt. Debbie says that the owl was the mascot of the school Brandeis, which who knows? And yes, and Tuto means owl, and then owl means death. Let me look up who Marisol is. Marisol Descalzo. All right. Please hold. Oh, Wendy, well, you came and you gave without taking, but I sent you away. Okay, this was Donna's first lawyer, the one who's standing next to Donna when she famously is in her first hearing with Judge Everett, and they're talking about her wanting to unalive herself, and she goes, "Oh my God," in the stark middle of court. Oh my God. And that lawyer hits her. She smacks Donna. I have it on a video. Hold on. It is peak iconic deliciousness. It's in this video.
Going to make a decision at some point. So after speaking to...
Okay, here we go. So this is Marisol Descalzo. What's your name? Descalzo. Marisol. Lysol Descalzo.
During the jail phone calls.
And
here's Donna. This is Marisol, that lady.
when she was booked into the jail here, she made a statement that she wanted to die. Now, before she was arrested in Miami, she also had a phone call with her son, who's obviously in jail here. 25-minute phone call. I've personally listened to it. She very clearly spoke about a plan to kill herself using sleeping pills.
I'm not suicidal. I'm fine.
Oh my God. Oh my God. And then she smacks her. She smacks her. Good morning, Jared. I know. Mrs. Adelson, please let your lawyer do the arguing for you. Please shut up and sit down, Mrs. Adelson. You are making a mockery of this courtroom. So, yeah, that's Marisol Descalzo. Where are you even from? I just wanted to see your picture first. Let's see. Where are you out of? Miami. So, this might be who's coming in at 10. The judge is like, we're going to start court at 8:45. And they're like, Kay, our witness doesn't get in till 10 a.m., by the way. And from what it sounds like, her flight lands at 10 a.m. Hold on. I'll look up the flights myself. Strategic defense with a human touch. I can't even think of the stupid word human now without listening or hearing that freaking the cell phone girl that they brought in yesterday that was like, in human speak, I added this up as a human. I'm a human. I swear to God, I'm human. It reminds me of that clip where freaking Mark Zuckerberg is like, when I was a human, I mean, I am a human, totally. I'm a human boy. Please believe me. Okay. Flights into Tallahassee today. Okie dokie, artichoke. Let's see. Okie doke. All right. There's a flight coming in. There's 2 flights that come in around 10 o'clock. Okay. There is one coming in from Miami, which is likely their witness. I mean, we've got to just assume. Doesn't come in until 10:06. Lands at 10:06. Lands at 10:06. The judge wants to start in 10 minutes for court. This is probably not even left Miami yet. And I'm sorry, but if last night, not even last night, if yesterday at 2:45, the judge says, make sure you have your fucking witnesses here on time, and you don't immediately call that witness and say, hey, can you drive up? Because it's like an 8-hour drive instead of waiting until, 2 hours after we're supposed to start court tomorrow to even land. Oh, hello, Lord's Girl. Thank you for being here. First time on the channel. Welcome to the fam. Good. You're fully versed on the Adelsons. Well, you are in good company, my friend. And good morning, Amy. And good morning, Zenjen. And good morning, Be Kind Rewind. And good morning, Nick. Okay. My goodness gracious. So last week, when the state rested Friday afternoon, they should have had everything ready to go. Okay, they're talking.
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Under Sheriff Google, however, at this point in time, this does not invoke the court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the undersheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you, Your Honor.
Oh my God. Okay. Okay. Good morning, Artemis, and good morning, Black Eyed Sue, and good morning, Brian, and good morning, Posi Vibe. Good morning, Yak Club.
Whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of trial. But that part of it, again, these are certain things I cannot assist with. Under Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who had spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, and she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with general counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
I'll catch everybody up in a second.
Sheriff Google, there's no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Why in the literal hell?
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor.
What a waste of everything. Yeah, I'll
Judge,
I'll catch
the
you up.
information that we provided to Your Honor was purely to put it on the record that we had followed that
It's on the
information.
record.
After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right, as to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
No, Your Honor.
As to the guard, if you need to follow up with a subpoena for this individual, as they have chosen not to speak with you, you need to do so with all haste. The jurors, at the time of selection, were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
During the lunch break, that will be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it'll be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Please bring in the jurors.
And Your Honor, I know that 3 of the witnesses are here. Mr. Descalzo's flight does not arrive until a little after
10 o'clock, you said.
Yes, sir.
Okay. So, here's the rundown of what happened this morning. They start.
Ms. Kappelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Yes, sir, I'm good, thank you.
Kappelman has nothing appropriate to say. Okay. So, they start this morning by the defense saying, sometime between yesterday at 12:30 and last night at 5 o'clock, Jack Campbell told a sheriff to talk to the officer that we wanted to talk to and told them not to testify for us. Told them that it would be in their best interest not to testify for us.
All rise, jury entering the courtroom.
So they call the guy up. They're like, did you tell her that? And he's like, no. She said, like, I don't know why the hell they want to talk to me. And he's like, all right, well, you don't have to talk to them if you don't want to. She's like, I don't even know why they would talk to you. Like, what the hell? And so then little baby dinosaur
Good morning, members of the jury.
Good morning.
Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor.
Marisol is
will
the previous
call Kristen Adamson.
But yeah, they're all bent out of shape. This person doesn't want to talk to them, and they're blaming it on the state, as if the state needs to prevent their witnesses from coming up, as if their witnesses have done anything other. Oh, Harvey has a couple friends, or is this just members of the gallery being like, we don't give any fucks anymore. We're just going to sit right next to Harvey, as if the state needs to try to tamper with any of the defense's witnesses. What a fucking joke. No, Marisol is not. Oh, is that who's coming up right now? Yeah, you might be right. Yes, you are right. You are right. You are right. Thank you. God.
Please raise your right
We
hand.
put a little bit of toner in your hair.
Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat.
Friends of
You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
Okay, Ms. Adelson, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes,
And-
I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
How long have we cared?
Yeah.
0 seconds.
In your work
Zero
as a
minutes, 0
family law
seconds,
attorney,
1.9.
did you have occasion to represent Wendy Adelson?
I did represent Wendy Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
600
How would you
pages long
characterize it?
is her divorce.
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because, unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now that are not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents.
No.
It's a very common thing for people to want to move to be near their parents, no matter how old they are.
No one cares.
Do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate.
Wendy was denied
so
relocation.
we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Okay. Did you have that conversation with Wendy Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
She said
so. In other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Okay. Now, the standard for a modification, what is that?
In my merch store.
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendy's case, there was also another component which no longer exists. But at the time that I had Wendy's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendy Adelson if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay.
Can you tell me more about other clients?
Have you ever been successful in convincing a judge to grant relocation?
I personally I've only won one case in 37 years for relocation.
So I wouldn't call that 50-50 then.
Would you say it's difficult?
I think it's difficult.
What does this have to do with
now,
anything?
Even though you've only gotten court approval for one with a client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that makes a recommendation. And if you have those things behind you, then it does help because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object. Or sometimes you have, like in my sister's case, which I actually did.
No
Have,
one
but I did represent my
cares
sister.
about your sister. Nobody cares about all these hypothetical
She moved
changes that
to
aren't
Atlanta, and then her
Wendy.
husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And
Roxana.
I think you said
Jeffrey.
you explained all of this to Wendy.
I did.
I really like
Was she
that.
aware that the chances of success were low?
Yeah.
Yes, I mean, I told her
Made
that this was her
out.
shot. I gave her, I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it.
You've won one
for many
case
reasons.
in your entire
but,
career.
including the fact that her parents were down there, that Professor Markel had a very flexible job. He
Morning,
had
people
family in
later.
South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I
Their
felt like she
schedule is
she had a
50-50,
really
Wendy
pretty good
says it
shot at
herself.
it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about the family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
Lawyers
And
get paid
when
whether you win your
completing
case or not.
the financial affidavits,
That's fun.
specifically
Yeah.
when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them and gave them to opposing counsel. Sometimes what does happen is the other side
Nothing.
has all the records.
Nothing.
For example, tax returns, we have to exchange
Nope.
tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns. So you do rely sometimes for the other side to provide the documents that you should have. But
Now-
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing or, but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to. So it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits, and I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow, so you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court at least.
Now, I want to back up a little bit. What happened with Wendy Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendy Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move, but she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendy go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendy about that, and then Wendy's parents were there, and I actually spoke to Wendy and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendy ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
She killed Dan.
At that point in time, I think she was upset that she wasn't going to. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although
like
the court denied the petition, would it have been possible for Wendy Adelson to offer Mr. Markell any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past.
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did. And at that mediation, we came very close to settling it, and we were there for quite a long period of time. But we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls, and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
before we had a court trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now,
My
I
point
know
is
in
murder is
pre-trial
illegal.
discussions you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement
100%.
is asked to be set aside for some purpose, like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in
100%
order to talk
positive.
about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall afoul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd. He is not with us anymore, and Professor Markel is not with us anymore. So a lot of people in that
That's
mediation
funny.
are gone, and Ms.
Good morning, Brandy.
Adelson has waived confidentiality.
You beat me to the punch, Ms. Edison. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired
Oh my
into.
God,
The state
none of
may
this
cross-examine as to all
matters.
subjects.
They've already gone over
You may
this.
continue.
Thank you very much, Your Honor.
They'd have already gone
Ms.
over
Adamson,
this.
can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute
100%
little
crazy.
dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that that actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement. And Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
Yes.
So based on what you've discussed, Mr.
That's the
Markel
first
was
thing I
aware
said.
of the non-marital status of that portion of
A little owner will go up.
Wendy Adelson's portion of what she would get.
He was.
I don't know, Len. Did we? That'd be funny. It wouldn't be surprising to me. These people don't know what's going on. Good morning, Philip.
And as you said, shortly thereafter, that case settled.
Within a week, I think, ish.
How long did your sister's case take?
Shortly
let us
after the
know.
divorce was final, did Wendy invite you to get her
Look at
groove
Donna.
back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendy Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well, and it was just sort of a Wendy's in a good place, come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
Thank you, dear.
And costs of?
That includes costs and everything, I think.
Oh my God.
Now,
I know that sounds like a lot, but
Yeah, I went
it
to
wasn't
the
that
party.
much compared to a lot of litigated cases.
okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did
I
this?
can't take it.
No.
I can't take it.
I don't don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, did the marital settlement agreement require that Mr. Markel pay Wendy and yourself certain sums?
So, according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendy for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendy did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendy did. So that was part of the agreement. He was supposed to pay me $10,000, he was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendy, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much...
She only likes fun things, like parties.
Once a week or once every other week, asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did you have? What did Wendy ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Ooh, you used your
Sounds
lawyer.
like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Okay.
Hi, Gila.
Did that prompt Mr. Markel to pay?
No, it did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to that my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. And he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense, because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money, and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached, and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendy at the time, is that is not a proper defense for not paying the money.
88 or 99.
Professor Markel, it was pretty obvious that he had actually written this pleading himself.
Oh, it's pretty
and the lawyer
obvious.
just signed off on it. It had
He's also a
footnotes, which is not
lawyer.
something litigation lawyers would do.
So you
It
know.
was voluminous, and it was very personal.
Like the
about
entire
what was
divorce
going on,
proceeding?
and Wendy and how he.
600
I don't think at
pages.
this point he alleged that he might have alleged that she had committed
Are-
fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically, if you think that an agreement is reached and it is not in good faith, or there's assets that were not
is
provided, then
I
you must file
on
within a
it.
year
Look at
for
her.
a 12.540
Fabulous.
to have the whole agreement
is
set
the
aside.
moment.
You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
You
it
filed a
was-
motion to strike as a sham pleading?
I did. I filed a motion saying this was an
good
inappropriate
for you.
pleading and it should be dismissed.
Congratulations.
Because it was. It wasn't the correct way to go about doing what he wanted to do. And and so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Now, in the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendy's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, that, you advised Miss Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that
100%.
if a
That's
case
what people
is
do.
heavily involved with mediations and lawyers and all these documents have been produced, you
More
had your
precious,
shot at it.
yeah.
So he was not going to be able to do that. Plus, I knew
Yep.
that he knew
100%.
about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So
This
it
is
was
not a
not,
contentious
in my
divorce. It
opinion,
goes into all the
a
details
successful
about what made this a
response, and I
contentious
told
divorce.
Wendy
Love
that
it.
wasn't.
Love her.
Not to worry about it.
Now,
Thanks, says Georgia.
there was a
Thanks, says
hearing
Sarah.
in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Miss Adelson.
So what happened
Hi,
was,
Sammy.
I wanted to take his deposition so I could find out why he wasn't paying. And their response
sounds
was to
personal.
want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order
You're never
so
allowed
that
to
he
ask
would
her
not
any
take her
questions.
deposition. We went to court on that issue in
We
front
went to
of the
court.
same judge.
To keep Wendy from
And
being
what happened at that
deposed.
hearing?
At
Right.
that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, The judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were poking my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
So
With
Dan
limits,
won.
yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent
Donna
to that, did
looks like she's throwing
Mr.
up in her
Markel
mouth and swallowing
file
it.
an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting.
The door, doesn't it,
and
precious Kim?
it was that Wendy wasn't allowing him to FaceTime with his children as much as he wanted to, that they weren't allowed to go to be present at the same birthday parties, that if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't, I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids. And I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time.
You
He
think?
also, I think it was that pleading where he went on a little bit more about Wendy and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
Donna's mellow
As
because
he's
it has
filing these
nothing to
things, are
do
you
with
still trying
her.
to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out. Still, I'm always trying to work out a case and not go to court.
Now,
if I
heavenly
can. So
pause.
we're trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this
But
so
they
we could
didn't
get the
have
money,
any.
and we could get his motions dismissed because they were frivolous.
Okay.
And hello.
Now, the one motion concerning his my client, Mrs. Adelson,
Sherry.
he referenced parental alienation. Have you dealt with parental alienation in your practice before?
Good morning,
I have.
Stephanie.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases
Like
that
the
were pretty
roadblock on
serious in the
Truscott?
past where little children, it doesn't usually
Like
impact
that?
teenagers. By the time they're teenagers, they've already they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become
Kids this young
completely
don't even
aligned
have
with
autobiographical
one parent
memories, so I'll put
inappropriately,
it.
and not
Everyone
because
right?
the other parent is doing something like abusing them or something like that.
Not ripping
It's
their
because
toenails out.
the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. It's not possible. And I told Wendy that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. and it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Okay.
Thank you, Gary.
Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendy.
And on that note,
And on that
we
note,
discussed earlier that
words of
it's not
Sade.
unusual for parents or family to be involved in meetings.
Is it a
Was my client, Donna Adelson, involved in any of the meetings that you had with Wendy Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
Yeah.
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even after even afterwards. They were fine. I had no issues with them. But I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Okay. And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Okay, just a moment, Your Honor. Nothing further this time?
Cross-examination.
Good morning, A Obsidian. Okay, good. Morning.
Good morning.
So you said you weren't aware of Donna Adelson's
Good morning,
involvement.
Mrs. Pisces.
in
She
the-
was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendy copy and paste them to send to you?
Stop.
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendy to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendy, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendy on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendy sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendy.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, you know, but
Right.
and I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay, even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because
Right.
they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So
and-
that's right. Yeah.
Okay, so that's why they were in the hallway.
That's why
most
they were in the
likely.
hallway. Yeah.
Okay, not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. I came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
Well, I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things.
my way.
But
Just so you know.
sometimes they take it really hard, especially family if they're not there.
Thank you
And they
for
do.
gifting membership,
Okay.
Sherry.
And you said Wendy was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendy Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No, okay.
And I have people do that. I mean, I've had to
Case
have my
closed.
own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendy, and then briefly, as far as I remember, because I mean it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, you know, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendy went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face.
No.
Okay. You talked about Dan Markell not paying what he was supposed to pay according to the settlement agreement. In Dan Markell's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact of that he was accusing Wendy of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markell held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforce it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then.
Could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step, and it would be difficult.
What ultimately is the consequence of that is my question.
So ultimately, the ultimate consequences, we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien, worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly, if he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendy Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did. Because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendy Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt legally the way that I was using it. I think his pleadings were much more, Wendy should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun, but for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem.
Super fun.
I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendy or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is when he did that.
Was that personal attacks on both Wendy Adelson and you?
Correct.
And he was alleging that Wendy Adelson committed fraud, right?
Yes.
He's alleging you committed
I
fraud.
did.
It got so bad that you had to get off the case so that you could be a witness on Wendy Adelson's behalf, right?
Correct.
I love the giggle from Sarah.
That's happened before, though. I mean, I've had.
Oh, it happens all the
before.
time.
And he alleged Wendy
Not
should be
intentional.
disbarred, you said.
Correct.
Not
And
intentional.
he's having issues with Wendy's
No,
mom, Donna
malicious.
Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal because she was saying things
High
about
observation
him to
station.
the kids, he thought.
And did the litigation between Dan Markell and Wendy Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendy Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No,
Why not?
because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides.
Okay.
But it's rare, and I remember all of them.
Right, but not contentious.
Sometimes I don't know with the suicides, I don't know.
That's all.
Thank you.
But not
Redirect
contentious.
examination.
Briefly, Your Honor.
You know that a ream of copy paper is 500 pages, and your client's divorce file is over 600 pages? Not contentious. Great. Glad we went over this. So glad. Is she trying to reboot right now, guys? What happened to her? No, she's doing great up there. She really doing great. Doing great. Fantastic.
You may.
Ms. Adamson, I'm going to approach and show you some. I'm sorry. Ms. Adamson. States demonstrative A, I think it's Court Exhibit 1, page 441 of the demonstrative. And then I'm holding 454. If you can hold that,
Sure.
please.
Okay.
Is that the March 26, 2014 pleading that Mr. Markell filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markell was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Thank you for showing us the grandma motion again, guys. I appreciate it. Carol, your questions are as good as ours. Nobody knows. Nobody
Ms.
knows
Adamson,
what's going on,
Did
including the defense.
you testified that the divorce was not contentious, but some of his pleadings post-divorce
Victoria.
were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendy Adelson and yourself.
Correct.
Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that. The only reason that I withdrew
loves
is
that.
because I was going to be a witness,
Loves it.
not because I cared what he said about me.
Had Mr. Markell not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know,
You don't know what she said privately, do you?
I do not.
Concerning Wendy Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
So you're not going to cut and paste from what a client sends you.
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendy Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendy, I don't remember that Wendy had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of chat GBT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
Whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment.
Yeah.
We'll retain her, but she's free to go about her business.
Thank you.
You may step down.
We'll catch her at the airport right before she's done.
Please call your next witness.
Thank you. Yeah. Hop out of the chat real
Your Honor,
quick
she,
and
the
hit the
next
like
witness is
button.
Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands.
I always forget when I'm watching live.
A very
like,
equivocal wave,
so I'm
but I'll
reminded.
take it. The bailiff will take you to the jury room.
Donna thinks this is
Resume at 10:05. Good morning.
that was pointless. I made a craft while we were on the break. Oh my
seated.
God.
Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
Is that lady in the blue suit? Yeah, she must be the next witness right there. Am I too turtley for your turtle club? Okay, yes, I will go over this. Oh, sorry, I'll remove that. Okay. Well, of course, it's how Wendy got her groove back, guys. fucking of course Wendy has a divorce party. Of course she has a divorce party. And everybody buys her TVs that are about $5 because it's cheaper than a Hitman. Do, 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 do. No, Wendy, I won't say it. She is a hoe for show, though. A hoe for show, though. I can't stand this woman. How proud was the lawyer to say... How proud was the lawyer to be like, yeah, I went to her party. It was called, you remember the title of Wendy's divorce party, but you can't remember these motions. It was called How Wendy Gets Her Groove Back. Oh my God, it was so fun. We had so much fun. Guys, I can't even freaking handle it. Okay, so this is what happened this morning. So they get in and the volume comes on like mid-sentence. And Zellman is saying, hey, the state prevented our next witness from testifying. And Judge Everett's like, what the fuck are you talking about? He's like, all right, so somewhere between yesterday at 12:30 and then at 5:30 when we got to the jail, he says Jack Campbell talked to the sheriff and told him to tell the woman that we were going to call for a witness today that not to talk to us, that it wasn't in her best interest not to talk to us. And the judge is like, okay, would you like to, hi, hotshot. He's like, would you like to disclose the witness that you're talking about? And they're like, no, it's a secret, but we want you to make her testify for us. We don't want to tell you who it is, but we want you to make her testify. He's like, okay. Is she under a subpoena? No, but we might want to serve her one. We definitely do now since she doesn't want to testify. Why in the fuck, on your second day of presenting your case, are you just now trying to subpoena witnesses? So they bring up the sheriff. I have a little sad bean. They bring up the sheriff. Hi, what happened? You hurt yourself? Yeah. Oh, let me hug you. Oh, let me hug you. Say hi. Let me hug you.
No, I want milk.
I'll give you milkies in a second. Hold on. Okay, so they bring up. Shh. I'll give you milkies. Shh. Stop yelling. They bring up the detective. Good morning, Watercolor by McCraw. And they say, so, hi, Beth. Good morning. They say, so, we hear that you guys are preventing the defense from, bringing witnesses in. That's pretty mean of you. And the guy is pretty much like, no. He's like, we had somebody come up to us yesterday who was just told, literally just told, because no surprise to anybody, just told that the defense wants to talk to her. And so she asked, hey, do I have to testify? Like, do I have to talk to them? I don't even know why they want to talk to me. And he's like, no, we don't have to testify if you don't want to. And then Zellman's like, we were told that she was on leave and that she wouldn't even be available to testify. He's like, I don't know anything about that. Like, if people are taking vacation because they don't want to talk to you, there's your sign. There's your sign. They're literally saying, I'm just not even going to work this week at all because I want nothing to do with this. So, shocking to nobody, the defense is not prepared. The defense is trying to call a last-minute witness out of the blue without giving this person any heads up or anything. And a shock to no one, they're lying, trying to make it seem like Jack Campbell has nothing better to do. Like, y'all, he has a grand jury trial today to indict Wendy. No, I don't know that for sure. Somebody's going to watch that and click off the video the second that I say that and go post it on Twitter. I hope, though, they do convene on Wednesdays. Maybe that's what George is running and going to do real quick. But yeah, the audacity to say that as if it was fact and accuse the state of that. Meanwhile, you guys are being accused by the state of bringing in a whole delicious cell phone for Donna to talk to Harvey on to bribe witnesses. So, I mean, it makes sense that they would think that the state is doing shady bullshit against them because they're doing shady bullshit against the state. The state. Yeah, I'm fine. I'm fine with starting a rumor. Wendy's getting arrested today. I heard it firsthand from Jack Campbell. He texted me last night and he's like, "Hey, Jackie." And I'm like, "Hey, Jack." He's like, "I'm only telling people whose names are Jack or Jackie. Wendy's getting arrested." And I'm like, "Great. Thanks for the info." And he's like, "No problem." And I'm like, "By the way, I'm having a party. It's called How Jackie Gets Her Groove Back. Please come." And he said, "No problem." Yes. That was a lot from the defense. That was quite a scandal. But oh yeah, Wendy is getting arrested. 1,000 quadrillion%. You can mark my words. I would bet money on it. If I was in Vegas, if Wendy was a racehorse like Jackie Fulford, I would put my money on her. 100%. Go tell Reddit, tell Twitter. Good morning, Wendy Adelson's fake tears. She will be arrested. There's no way. There is no way that the state is going to sit here and drop all these. And I said this before this trial even started. I said, we will know who is next by who they are pointing to. Because every trial, they have pointed to the next person. Okay? At Katie's trial, it was all about Charlie. At Charlie's trial, it was all about Donna. And at Donna's trial, who's it about? Wendy. Even the defense themselves are saying Wendy is next. So it's Wendy. It's Wendy. We have not found out all this information for, yeah, see, Lord's girl is Jackie also. And Jack Campbell called her right after he called me. So, Juicy, can you say hi to everybody? She's nursing. Well, I mean, really, why else would they give us all of this information? And maybe this is a bump for Wendy. Because not only that, but you know who was sitting in the courtroom almost the entire time? Wendy's lawyer. Wendy's lawyer has been in the gallery every single day, probably to see what else they dig up on Wendy. Because while Wendy was on the stand, Georgia was bringing out new information that nobody's ever seen. Why else would he be there? As if John Lauro has nothing better to do. Because in every other trial, he left with Wendy, and we never saw him again. So why else would he be there unless to sit there and, Ryan, to sit there and see what sort of dirt they have on Wendy, to see what else they have on Wendy. You know, it wouldn't surprise me if Isom got a phone call asking if Wendy's going to be the next one to be arrested. Brian says, hopefully she F's up and thinks Taco Bell is not U.S. ground. And she's got a long way to go to make it to the border of Mexico. And she'll ride like the wind, ride like the wind, dun, 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 dun. Ride like the wind, dun, 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 meow, meow. Okay, so let's, I can appreciate them likely wanting to get a deal for Wendy, but what does Wendy have to offer the state to get a deal? And nothing. She has nothing to give. Everybody else is wrapped up in prison. She has nothing to give the state to get a deal. Beth says she can barely listen to the defense witness or team. Besides boredom, they're pointless. Almost worth it because she feels like it just helps the Markells correct. Good morning, Tenacity for the Truth. When legally untoned blonde. Stop it. Told Wendy that she no longer had a shot at relocation. Wendy said, hold my beer. Yeah. Speaking of shot, let's look at Wendy's being watched 100%, Stacy. 100 quadrillion%. She'd be absolutely idiotic to try to flee after what happened with Donna. All it does is make you look more guilty, and you're not getting away. Okay, let's watch this.
Did you have the opportunity to speak to her on the telephone when you were away in New Jersey?
Absolutely.
Okay. Would you say you had regular contact throughout?
Regular contact.
Okay. I'm going to tell you, this nice young lady over here, she's typing every word that we're saying, and I have a bad habit of talking over people, and she will shoot me if I do that. So I'm going to try.
And I have a bad habit of speaking quickly.
So you and I are going to need to make sure we wait until the other person finishes before we start to speak, okay? So you had regular phone contact with Mrs. Adelson while you were in New Jersey each year?
Yes.
And then spending time together while you were in Florida?
Yes.
And you said it started out in Aventura, Florida, and that was close to where she lived. At some point you got your home then in Naples, is that right?
That is correct.
Okay, but still continued to spend time with the Adelsons?
Yes.
Okay. Did you have an opportunity to meet her children?
Yes, I did.
Okay.
I met two of her children.
And who?
What's your emergency?
It's right next door at my house, which is 2122 Trescott Drive.
Can you repeat that for verification?
2122 Trescott Drive, repeat.
Okay, the phone number you're calling from?
I'm calling from 850
Sidebars for Thursday and Friday.
Okay, tell me exactly what happened.
We heard a loud bang and a car pulled away from next door. I came over and looked in, the garage door was up. Now I thought the gentleman was backing out, and I went back to my house, but he never backed out. And I came back over, and his driver's side.
I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman,
All right, hold on. We missed a couple minutes of what he was saying.
witness.
Maybe just a couple.
When we advised Ms. Bailey.
All right, I'm just going to back up a smidgen. The best...
When we advised Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Linda Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by the Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Wow.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know I'm going to go over to the court report. Now I'm going to go over to the court reporter's office to check the sidebar. From there, we will finish this matter and resume the testimony.
Holy shit, guys. What messy sluts the defense is. Holy God. Holy God. Hi, Mrs. Jones. Yeah, well, I'll get you a popsicle in 1 second. So Linda Bailey, the girl that we saw in the navy suit, standing there right before we went to break. Surprise, surprise. She was not sequestered. Surprise, surprise. She was sitting in the courtroom. This woman is a lawyer. For God's sakes. PLN, another witness sequester violation. It doesn't matter that she doesn't have a path to ineffective counsel. Having shitty lawyers is not all you need. I mean, if it was all you needed, then bang, right through the eyes on that one. But this is not it. So not only do you have to have shitty lawyers, but you have to show that you could have potentially had a different verdict if you would have had good lawyers. Which not the best lawyers in the world could not help. It is not the bailiff's job to keep all of the defense's witnesses out of the courtroom. The defense, okay, one time, maybe you can say, all right, well, maybe that guy just didn't know. This person is a fucking lawyer. A lawyer was sitting in the gallery watching testimony, watching the other lawyer's testimony. This is your job as the lawyer to tell your witnesses how they're supposed to behave in court. That's their literal job. It is very disrespectful. That witness specifically should know better, Kaylee. Should 100%. She is a lawyer. What kind of lawyer is she, other than shitty? She's a Tallahassee divorce lawyer. So do we want to bet that this is another one of Wendy's lawyers? More than likely. And here we've got, this is the I doubt Linda Bailey was the one with like the kind of shoulder length blonde hair that was standing. I'll back up a sec. She was standing right next to the defense before we went on a break. And the asshole was in the gallery. A divorce lawyer listening to the testimony. So this right here in the middle, holding this white notebook,
All right,
is
please
Linda
stretch
Bailey.
your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Unreal. How... I mean, this is just making an absolute mockery. So she's a divorce lawyer, and they're calling her for the defense. So I'm going to assume that she was Wendy's divorce lawyer. because she's a divorce lawyer out of Tallahassee. Okay, let me go and get Juicy Bean a popsicle, and I will be right back. Yeah, I don't see how the other guy that was in the gallery, at the very least, we were able to say, okay, well, this had nothing to do. The other guy was the real estate guy. Okay, hold on. I'm going to get you a popsicle. Who showed houses, I guess, to Donna and Harvey back in like 2011. It had nothing to do with anything, but it also didn't have to do with anybody else's testimony. This is not good. All right, I'll be right back. I got to get her a popsicle. If you leave me now. What do you need? You need help? Okay. Hold on. I need to help the gerbil. She's having problems. Hi, Cheryl's World. If you leave me now, you take away the biggest part of me. Ooh, darling, please don't go. Oh, yes, you've missed a lot. I'll give you the rundown. Good morning, cornbread. That was a whole delicious lunch. Okay. Okay, so Cheryl's World. Oh my gosh. All right. So this is what happened. So Zellman starts today by accusing the state of having Jack Campbell tell the sheriff to tell the deputy that the defense wanted to have pull as a witness, at the very last minute. He says, thank you, Jennifer. He says, they tampered with our witness, basically. He says that Jack Campbell told the sheriff to tell the deputy that it wouldn't be in your best interest to be a witness for the defense, which that is correct. But turns out that didn't happen because they pulled the sheriff up and he asked the sheriff under oath, hey, did you say this to the witness? And the guy's like, no, she literally came up to us yesterday and she was like, why is the defense trying to talk to me? Ew, like freaking, there's a horse outside of my office and she's like neighing and braying and bucking and I don't know what's going on. And so neighing, braying, bucking, she's like, should I just tie her to a tree and like try to feed her some oats? And they're like, hold on. What does she want? And then the lady's like, I don't even know. Like, I have no idea. Do I have to talk to this horse? And they're like, no, you don't. You don't have to do anything that you don't want to do. And so the judge is like, do you want to tell me who it is? Because, like, if they're not under subpoena, I just can't compel people to testify on your behalf just for the hell of it. And they're like, no, we didn't pull a subpoena yet. Dude, we are day, 8 into this trial? We're day 8 into the trial, and you're just now thinking that maybe you should pull some witnesses? Like, I said this literally back before this even started. I said, will the defense even be prepared because of how many bullshit motions they have filed? Will they even be prepared because of how many motions they have filed? And guess what? They're not. A surprise to no one. A surprise to nobody. Yeah, I mean, would you? If a horse just showed up outside of my door right now and was like, hey, I'd be like, help. Can somebody help me? There's a horse here. Please help me. Join Jen. I don't know. Good morning, Brett M. We're going over, if you want to back up like 2 minutes, I'm going over what happened this morning. Yes, that was Kristen Adamson. What the hell? Who called her the funniest thing ever? Legally Untoned Blonde. Who was that? Hold on, I'm going up. Tenacity for the Truth called her Legally Untoned Blonde. I cannot. So, oh yeah, pizza would be nice. Okay, so they're like, we're not tampering with your witnesses. Like, bring on literally anybody. You can't do anything. You have no power here. Be gone. So then Legally Untoned Blonde went up, said the same thing over and over. Like, I guess she's getting, speaking lessons from Charlie, repeats herself 12 freaking times. Basically, the point that she got to was, this is a contentious divorce. They ask her if it was a contentious divorce. She says no, and then goes to list all of these things that are outside of a normal divorce proceeding, including her having to trying to sanction Dan to get him to pay the money because Dan's not paying because Wendy owes him money. Sounds like a mess. Sounds like an absolute mess. And then she gets down and the defense is like, okay, we're ready for our next witness, but she's going to be a long one. And it seems like this is a divorce lawyer from Tallahassee. So this seems to be another divorce lawyer of Wendy's, okay? I don't think we've seen her. I don't think she was in Charlie's trial, although I did black out anytime Rashbaum was talking. But I don't feel like we've seen her. But come to find out, we have deja vu because this bitch has been in the gallery. You're supposed to keep your witnesses outside of the courtroom. Yes. Was June 15 minutes late for her testimony? Yes. But was she sitting next to Harvey, listening to everything? She was not. And so Judge Everett's like, Georgia, can you think of a remedy for this? Like, what can we do to fix this? And she's like, well, not violating the rules in the first place would fix that pretty well. Thanks. They're probably going to be disbarred anyway because, oh, and I have this in emotion. Okay. It's fine. I mean, I can sum it up in a few minutes, and you missed a little bit, but not much. You're fine. We've been mainly just sitting here. I literally talked over poor little Kathleen or whatever the hell her name is, the last freaking girl. I'm calling her Kathleen no matter what her name is because that's what her name is to me. I talked over her pretty much the whole time she was on the stand because we didn't want to hear her bullshit. Most of it was just repeats. She kept talking about her sister's divorce, and just like nothing that mattered. Okie dokie, artichoke. All right, so artichoke, that's the color of her shirt, actually. Artichoke, okay. Okie dokie. I'll just put in by date. All right. So basically, okay. So we all remember, I'm going to assume we all remember the court hearing when they brought in all the new evidence. The state's like, okay.
So hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Yes, sir.
Please make your arguments.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts, and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now.
Judge,
why should this witness be permitted to testify, Mr. Zellman?
Judge, The prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that.
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom and appropriately in violation of the rule of sequestration. When this was addressed at Sidebar, you brought up the topic.
And
the
an
state
open court.
only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Shit.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at Sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So,
as to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
He can't even believe it.
Reviewing Earhart, exclusion of the witness. Court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that proffer can be taken on this matter. And after that, I will step down, briefly review what I need, and make a ruling. Please raise your right hand. Do you swear or affirm?
And she was sitting in the gallery this whole time.
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
And Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markell divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts, and I have known Kristen for 40 years. We went to law school together, and I know how she practices. I practice against her often, so I had some ideas about the lack of strength of Mr. Markell's motions, and she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donald Adelson and Wendy Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendy Adelson and Dan Markell. I read some text messages between Donna Adelson and Wendy as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did.
And why was that?
Just to confirm that I had the facts correct.
Okay.
And I did.
And
What the fuck,
you
guys?
sat this morning through Miss Adamson's testimony.
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Miss Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Kaplan, an examination for the purpose of the proffer.
So she knew the facts or she didn't know the facts? Because she came in here so she would know the facts, but she knew them.
Before, was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
I love that one. Guys, what a mess. I love that one from Maddie.
One for Mary, too.
What a mess.
Maybe one for Mary.
Maybe one from Maddie. That's a good idea. You're so nice.
I want one for Mary.
Well, you can look at one for Maddie, okay? She came up demanding a bike. All right, I'm going to get you one so you can look for Maddie, okay? Here, baby.
I mean, really, this lawyer knows enough to say, no, I didn't learn anything new. Why did she have to be there at all? Thank you, Maria. Good morning. Why did she have to be there at all?
This is for Mary.
You either...
And the princess one.
Oh, you want to look at a princess one?
Yeah, for Mary. It's for Mary.
Okay.
For Mary.
You either
Marina.
know what you're going to talk about
Yeah.
or you don't.
Mary.
Like, I'm not a lawyer, but this makes no sense to me. How are you coming in here not knowing what you're going to testify? How do you come in here not knowing the facts?
For Mary.
Oh, that's a great one. Whoops. That's a great one. I mean, seriously, like, how would you even... That doesn't even make sense. That, like... I deal in truth and logic, and that doesn't have either one of those for me. Yes, Carol. So my husband and I each had 3 kids when we got together. So we had 6 kids between the ages of 1 and 4 when we got together. And then when our oldest ones were 10, we had our first together. So we had 3 together. So we have 9. And so our age ranges are from 2 years old with this juicy little baby up to almost 21. And my 18-year-old, oh geez, she just turned 19. My 19-year-old is driving up today. She's on leave from the Army. So she's going to come see me. I'm excited to see her. Yes, dads are people too. Exactly. She wanted to make sure that her testimony matched the First Lady's. Why else would she need to know what she already knows? You either know it and you don't need to sit in the gallery, or you don't know it and you do need to sit in the gallery. You can't do both. I'm sorry, but she should be prevented from testifying. I mean, I feel like if this was Judge Hankinson on this, he would have like held the frickin' defense in contempt by now. Jackie would have been held in contempt the first day she was late when she frickin' snorted an Ambien at 4 a.m. and 100% they would have had sanctions held against them, more than likely. Hello, Zen Jen, because the defense had another witness sitting in the gallery before they testified. She should be excluded from testifying. 1, what is she going to add to the defense? Because the last lady added nothing. And 2, I mean, this was literally one of the last things that the judge said to everybody on Friday was, let's have no more, rules of sequestration, pretty much ignored completely. They would be having a fit if the state was doing this. They would have an absolute fit. Jackie would be up there jumping up and down like the wee little rat mouse she is. And yeah, the jurors, I mean, honestly, it's got to be nice for the jurors to be able to take a break. Yeah, Dumber and Dumbest Law Firm, Hazel says 100%. Yeah, I'm sorry that she should... They are scheming, scamming. I can't. And not only that, but, and I was starting to talk about this before he came back, and rude Judge Everett will probably cut me off again. But the wiretap that the state got back in when was it? I think it ended in April. They got that because they got word that the defense attorneys were sneaking in a personal cell phone for dear Donna to use to call Harvey to be able to bribe witnesses and it not be recorded by the jail line. What baby? Not only that, but there's apparently hold on. There's apparently video of this. Okay, there's apparently video of this. And that is a violation and a half, guys. When you go to the Leon County Jail, it says on the wall before you even enter, you are not allowed to bring in your cell phones, lawyers. You are not allowed to bring in phones. So not only is she bringing in the phone, it wasn't like, oopsie doopsie, I forgot it was in my purse. She's bringing in the phone and handing it over to Donna so Donna can discuss shady dealings with Harvey. Apple smartwatch, whatever. You still have to be close enough to the, you still have to be close enough to the phone, right? No, I guess some of them have cell phone capabilities now. It's been a hot minute since I've had an Apple Watch. But in these phone calls, there is talk about them wanting to harm both Rob to prevent him from testifying and Drina's mom to prevent her from testifying. There has not been yet, Hazel. Not yet. And we have not heard about it in court. We haven't heard about it in court yet. So, yes, the defense are shameless. I agree. And perfect for Donna also 100% agree. I think this is just absolute despicable behavior. Okay. So most of this came out because basically, okay, so the defense gets all up in arms and asks Judge Everett to recuse himself because he has to be prejudiced against Donna now because he knows he's the one who, I guess, helped to approve the wiretap. And this wasn't an FBI wiretap like the first one was. This was a state-approved wiretap, which is allegedly notoriously hard to get. Like, they are almost never given out a state wiretap, a state-approved wiretap. So there has to be, first of all, an overwhelming amount of evidence that you need this. And then you have to prove that not only do we have an overwhelming amount of evidence that we need to tap somebody's phone, but that this information will not be able to be, received without this wiretap. Okay. So, which of course, the defense says that the affidavits presented to the judge lied about the content of the conversations between Donna and her husband and alleged that among the false allegations were accusations that the defendant and her spouse engaged in conversations by use of the undersigned cell phone / watch, you guys are right, to plan harm to Robert Adelson, Katie McManawa, and the mother of a jailhouse snitch. Okie dokie. Okie dokie. So yeah, and I'm sorry, but the state is not that messy. The state is not going to accuse the defense of something that they are not sure that they've done. Like, if the state didn't think that the defense was doing this, this would never have happened. They wouldn't have done this. Yeah, potentially Steph Doyle, Harvey could get charged for witness tampering. Unless they have more evidence on him, I think that might be, all he could get charged with. So they might do like a double, they might arrest him and Wendy at the same time or very close near each other, because if he's, getting charged with something lesser, then, obviously Wendy would likely be charged with what everybody else got: murder 1, conspiracy, and solicitation. So, okay. I have the deets on the Vietnamese resort as well. So, it was a villa that Scott Radius basically helped facilitate the purchase of this villa. It was being built at the time, and I read out all these texts the other day between Harvey and Scott and their WhatsApp messages. Harvey's WhatsApping Scott, but Scott's the one who called the FBI about Donna and Harvey planning to flee the country. So, Harvey, okay, never mind. Let's see what he has to say. I'm going to say...
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at Sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial, as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand.
Okay, so...
Are there any additional matters that need to be clarified This needs to occur so we don't have any more issues with witnesses or
All
other
three of
problems.
these ladies are future witnesses sitting right behind the defense table. So basically, he's going to let her testify, but he's also going to give an instruction to the jury saying, this bitch was here when she wasn't supposed to be here.
All rise, jury, enter the courtroom.
Why is Donna wearing a tuxedo shirt today? Anyone tuxedo shirt? Donna.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn.
You
Do you
idiot.
swear or
Stand
affirm
up.
the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Are you here, Miss Bailey? She's like, sorry, Jackie gave me some horse tranquilizers, and they are great.
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
It's the Dumb and Dumber.
Tell us briefly
shirt.
about your
Tuck
educational background.
Stop. The blue one.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So, math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adamson, so we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you've practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, B-A-I-L-E-Y.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay, and do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to.
And they also send more peer reviews out every 5 years. So all of the other
opposing counsels, other board-certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers.
Did anybody teach you?
And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting-related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir dire the witness as to their training or experience.
No, Your Honor.
Any objection to her ability to provide an opinion in the fields of marital or family law?
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendy, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendy Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendy Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendy Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's some, the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time. When
Wendy Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So, in other words, when Wendy initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then,
in other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendy's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by a court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendy's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce conversations that he had had with Wendy that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendy essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendy Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendy waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court to say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change. And the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson-Markell case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the petition, the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably, and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke about earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery?
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendy about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days. And then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140-something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendy Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool, where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
Okay. And aside from those two, were I believe Wendy, was she deposed?
I don't recall seeing that Wendy or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markell?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markell's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markell's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markell was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendy Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendy filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally, I don't think it was a very strong legal position.
Okay, and we'll come back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied.
Mm-hmm.
Did my client, in the emails you review, appear to push back on Wendy and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think, was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Is it possible to undo this? And then Wendy responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw between them.
Certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. Sometimes I say, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendy was sent by her mother. Did you see evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
Okay. And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit, which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school, maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markell had asked for sole decision making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision making, which is extremely difficult to do. The only time a parent gets sole decision making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
Now, later...
But it was very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she
Correct.
waited to file.
She did. And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation would be dismissed. So,
now, prior to final judgment being entered, would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide-ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
Routine.
that. Okay. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it's a few months period, even after these motions had been filed that kind of upped the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him and the boys for ice cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
You mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? Approach with courts 1 states demonstrative A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000, and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here, she's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markell?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markell emailed the parenting coordinator and Wendy Adelson complaining about a host of issues.
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendy in the same email in December 18th, maybe, of 2013.
From your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendy to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, Grandma thinks you're stupid, or something like that.
Did Mr. Markell file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markell?
I'm sorry, Mr. Markell's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendy had these other financial violations. And then she referred to the Schwab account that you've heard about, and a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendy. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
I'm bored to death.
What defense did he claim to have to avoid paying Wendy Adelson as he'd been ordered?
We already went over this.
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was
no, because how would he be able to argue
have
if he didn't know it existed?
Updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents.
I'm going to pause this bitch because I've got something to say. Having 2 of Wendy's lawyers come up here back to back to testify on Donna's behalf somehow is so incredibly prejudicial. Like, obviously, Wendy's lawyer is going to be on Wendy's side. Like, obviously. Obviously. This is the dumbest shit I've ever heard. Okay, I'll play it now. This is a good close-up of her teeth. No, she has one way in the back. Do we see this? I don't know how to zoom in on this. I'm not as technically challenged as Jackie Fulford, but do we see her teeth? Everybody, do you see her teeth? Are you enjoying the teeth?
Documents. And then, according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah. He was just trying to say one good breach deserves another or something like that, and it wasn't legally
I don't know how.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
I would
Now,
make
if
it.
if a party in an action believes that there has been,
Dan wouldn't sit in the back of the gallery when he was supposed to testify in a trial. I can guarantee that.
fraud in the underlying, securing the underlying agreement, is there a way in which they can contest
She
that?
said Donna's
There
words
is.
once.
If you're
or Donna's
alleging
name
fraud,
once.
and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud.
They shouldn't
so
be
if you
allowed
find
to
out
talk
later
about him like that.
that they had won the lottery
Hi,
before you
Steve
didn't
Sullivan.
disclose, or that they had some stash of gold bars somewhere, or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that
Every time I see your name, Steve Sullivan, all I can think of is the song from Bye Bye Birdie, where they have a song about Ed Sullivan, but I sing it as Steve Sullivan. We're gonna be on Steve Sullivan.
talks about maybe there was some minor $3,000 to $5,000 tiny IRA or something like that that was never disclosed. They just had forgotten about it. It was very small in relation to.
You know, there's a way to talk about this stuff without putting Dan down, because all of this was like, oh, I don't know why he did that. No, he had no right to do that. Blah, 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 blah. It's all fucking so yucky. I'm sorry, but if God bless Ruth and Phil Markel, because if I were in their shoes, I would be in one shoe because I would have thrown the other one at this bitch right here.
The rest of the assets, and the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle.
No, that was the one who
Sure, and it had to have impacted you. In this instance, it was clear from Mr. Markel's own motions, he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
Proper pleading?
No. What happened was he did the January 31st response, and then he did the motion against Wendy on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion.
I'll summarize it. Dan's a jerk and Wendy's perfect. There you go. That's what you missed.
Being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all.
What does this do to further the defense's position that Donna didn't kill Dan? What is this doing? What is this doing? You tell me. Write your answers in the chat.
All of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't
didn't
required.
know Dan's
He
on
asked
trial
for
today.
A certain number of phone calls, and a number of phone calls wasn't required. He was asking for, there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would.
Okay, so just real quick again. I went through a divorce in Florida just a few years earlier than this. I think my divorce was finalized in like late 2009. And first right of refusal is actually like one of, per the court, because the court has rules in Florida. Florida is honestly the most fair court, or the most fair state to get divorced in, because everything is focused for what's the best for the children. It doesn't matter about the mom. It doesn't matter about the dad. What is best for the kids? And 99% of the time, they want the parents to have equal time sharing. And first right of refusal is one of the tenets. It says that in the very beginning of your parenting plan, that you should have first right of refusal and that neither one of the parents should be disparaging the other one. So she's saying this like this was some crazy ask that Danny wanted his kids, or at least offered his kids first, and then, wanted to talk to them at night. Like, the audacity. And my husband personally, like, when we both got divorced, our kids were little. But my husband also wanted to go and kiss his kids at night. That's not an asshole thing to want. That's like a good dad.
Maybe go have dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them. And they were little babies. And he didn't like that because he wanted to be able to go to the child care during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but
What does that matter? And you know what? No, that's bullshit, because Wendy even says in her police interview that if they missed the kids, they would go in and have breakfast with the kids when it was the other person's day. And we had a very similar situation because my husband's ex was not an easy person to deal with. And she was putting the kids in daycare from like 6 a.m. to 6 p.m. And they were 2 and 4 at the time, babies. And they were in there for 12 hours a day. And he asked her, like, hey, can I get them early on these days so they don't have to sit there? Like, if I'm out of work early, can I pick them up? And of course it was a no. But I mean, this is insane. She's saying all this stuff like this is the most insane thing. For all you're doing is proving what an excellent dad Dan was. And how ridiculous it was that, like, if he wanted to go see the kids, if Dan's missing the kids, guess what, Wendy? They're probably missing him too. So for you to say, no, you can't go visit them at fucking daycare when they're not with you anyway, what is that? How is that hurting Wendy for him to go see the kids at daycare, other than her freaking, virtue signaling bullshit that she doesn't want to go see them when they're in daycare? And I'm getting heated.
He wanted to do that. And he
they
wanted
were tiny,
her to
Sherry.
Go to a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order.
This woman needs to shut her face before I shut it for her. I don't know if I'll be able to be in the gallery at Wendy's trial. You might see me get escorted out by bailiffs as I snatch the back of Wendy's unflat-ironed hair and just run out the courtroom.
To enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful.
Fighting with Dan on the last day, that not letting Dan see those fucking boys. I can't even talk about it. It's so fucking terrible. She's such a piece of fucking shit. Oh my God.
Yes, it looks like on April 11th. Nope, that's his response. Let's see.
Fucking atrocious, to say the fucking least. Fucking atrocious.
Yes, it was
what
before the
fucking
it was
human piece of
my recollection was correct. She filed the motion to dismiss on March 10th to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made, well into this very long motion, was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show a material and substantial change in circumstances, and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Okay. Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion he says, I don't know if this is true or not. I don't know if Wendy was present or not.
Yeah, no, 4-year-olds could never be truthful in there. Juicy Bean, little Juicy Baby, is not even 3, and she could tell me an entire conversation that she had with her dad, word for word, verbatim. A 4-year-old would most certainly be able to remember something as shocking as grandma, the person you love, saying, Dad's stupid, also a person that you love, and that they hated him. I was 3 years old when my dad married my stepmom. I'm sorry, I'm like screaming. I see my mic audio going up to red. I was 3 years old when my dad married my stepmom. I remember the wedding. And I certainly remember the way that I was treated. And kids remember that stuff, especially if it's freaking traumatic. And they certainly remember losing their fucking dad. I hate this bitch. I hate her more than the last woman, and I didn't think that was possible.
But I would like Wendy to make it stop, if it's true.
Did this motion, the March 26, 2014 motion, that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.45, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit, and they kept the children home from school, that he couldn't go visit the children at school, so he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the
Great point. Great point. Donna understands that they can memorize all 44 presidents, but can't remember when you called their dad stupid to their face and said that you hated him. Get the fuck out of here. Great point, Holy shit.
Names. If she went out to dinner because her mom was in town and gave her a chance to run out and see a friend or something, he wanted Wendy to have to call him so he could watch the kids, even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not my rule. What I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing, and so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
Brian!
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all because it was a complete waste of everyone's time and money and emotion because it was baseless.
And this is not a waste of anyone's time.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his violence?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms.
Exactly, cornbread.
In reading the motion, does it appear to be intimidating?
It's messing around.
I think when I was making notes, I put insert by rule here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
they shouldn't have. And that's one of the reasons I wanted to call Kristen, because, again, when I read that motion, I was kind of taken aback that a lawyer would sign that and allow that to be filed. And I thought it was kind of nonsense, and I wanted to get Kristen's take on that and see if she agreed, and she did. And she said that she had advised Wendy about it, and that's what I would have expected from her.
You know, her saying that she has to sit in to listen to Kristen's testimony and then testifying that her and Kristen spoke at length about what they were going to say here is a little fucking sus.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendy had sent her mom a couple of...
And even sped up to almost 2 times speed, Zellman still sounds like he's talking in a normal cadence.
Documents. I know the petition for relocation, that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because, like, relocation is extremely difficult, and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition, but after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the motion. It's certainly not from. I saw nothing. Either she communicated the motion to her mother, or the mother reacted to it. I didn't see any responses.
Would Mr. Markell have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markell have been able to sustain his burden of proof for that motion?
No, I don't think so at all. You know, if you're talking specifically about like point 8 about calling him stupid, his only evidence was a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just there's so much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. How many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markell that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different order. So 570 though.
Do you know how much in attorney's fees Wendy Adelson incurred, attorney's fees and costs, for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
Okay.
Don't you
in
consider
particular, do
getting
any come to mind that
high
involved an attempt to seek
conflict?
relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Can I show the witness to the demonstrative?
You may.
Was it your sister's case by chance? Guys, I fucking hate this. Oh, are they showing a court? Is this a? Are they showing a divorce proceeding that is bigger than Wendy's? Is that what they're doing here?
Volume 4.
This is that's what they're doing right now, guys.
Do you recognize this file?
Yes, I think I forwarded this to you.
And this are these 10 volumes.
Zellman, focus on the Zell.
Hotly contested relocation case.
Well, I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so
this
perhaps
has
only
to
one of those
do
volumes
with anything.
So
how about let's show a normal
clerk's
divorce
file
proceeding?
in the case
Mine was 2 pages long.
Is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages for no vote.
Thank you.
Please sit down, sir.
Is he just going to leave all that shit up there and walk away and be done with this?
Can you tell the jury what the issues were in that case?
Yes.
What's the relevance?
It's a stage.
Just
Judge,
left that
may we
right in
approach?
front of her face.
No.
Judge, we're entitled to make a record. I believe I have the...
You're not.
The bailiff will take you to the jury room.
You're not entitled to do anything, in fact. Entitlement is what got us into the position we are in right now. You know what? Georgia has been very quiet this whole time.
You may be seated.
This
The
is the
relocation
first time
issues within this case are certainly
she's
relevant.
objective.
As to a separate other case, what is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is witnesses identified this as a hotly contested custody and relocation matter.
Pointless.
I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendy Adelson and Mr. Dan Markell.
Councilman, any other argument on this issue?
It's relevant, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, Again, the relocation that is disputed within this case as it relates to divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Shut the fuck up. Don't talk to Everett like that. How
Ms. Bailey, please step down. Step out
dare
of the
you?
courtroom doors. If you can radio Deputy Bump to leave the jurors in the room, please approach.
How dare you? Do you know what Judge Everett's going to do? He's going to take him by his little fucking shirt and he's going to pull his tie really tight and he's going to say, don't you fucking dare sass me like that in the fucking courtroom in front of God and everybody. How dare you? How dare you sass Judge Everett? Yeah, get the fuck out of here. Get out. You go. Go. Nobody wants you here. Nobody wants you.
Do not make any gesturing. Do not make any comments. Do not make any expressions in front of the jury in any way that would be intended to inappropriately.
I'm not going to be. I won't be able to be at Wendy's
Please
court.
use the restroom, stretch your legs if you need to, and continue with the witness after that.
I'll be taken out. I can't help my fucking face. I cannot help my face. No. The fucking audacity. How dare you sass Judge Everett, the Honorable Judge Everett, that you literally, like, do you know who has a freaking unfair bias? You, to the fucking judge. Like, the goddamn audacity. Who are you? Who do you think you are? Fucking, I hold everybody in contempt except for Georgia and Sarah. Everybody in contempt. I cannot fucking believe that he literally, yeah, Judge Everett's going to be like, Jackie, although I do find your videos absolutely hilarious and I listen to the Donna song on repeat, you have to stop with your facial expressions because I'm going to be like, what the fuck is that? I wouldn't be able to help myself. I don't know. I would have to take something. I mean, Harvey will probably be in prison by then, so maybe I'll call him now to get my prescription. Well, the jury's already going to be given an instruction that this witness sat and watched the other witness. Are we on lunch? Are we on lunch, guys? Is that what's happening? Whatever, we'll still look at something. All right, in case you... Oh, Donna's stupid little face. Yes, thank you, Christina. Yeah, if you just want to close out the live chat, if everybody does it at the same time and hits the like button, we won't miss a thing. Yeah, so that's a lot. That was a lot of nonsense. Okay. Dr. Obed. Dr. Obed will still be out of prison, more than likely. Dr. Obed. Okay. So, in case you're new, in case you didn't see the craft that I was crafting while in the middle of court, here's how Wendy got her groove back. There we go. This is my skill set, Judge. I know. I need something. This is true, Steve Sullivan. The defense is better than Ambien. All the jurors are asleep. I wonder what frickin'... Oh, and for those who don't know, I'm going to be live with Judy tonight from AA Legal Focus. I think it's going to be streaming on both of our channels. I don't know. I don't know how to use StreamYard. Yeah, that would be awesome. No, she was super, super sweet. Not she was, she is. Patty is awesome. But I'm going to be on live tonight with AA Legal Focus. We'll probably both be pretty tired, so please come and support and give us a little pep in our step. Yeah, I think he said, we can go back. We can go back. Because I don't know. I wasn't paying attention. I was so irritated. And we had it on like 8 times fucking speed anyway. All right, here's where they get scolded.
Not make any.
Get out. Go. Nobody wants you here. Go. Keep walking. Keep walking. Keep walking. No. No. Take your tiny non-Junipchinda bag and get the fuck out of court. Get out of court. Harvey. Harvey has a bright yellow cell phone. Yes, this is the, that's the gourmet meal guy.
Remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. The jurors using the restroom.
They are.
Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
Did he say after that? Or after lunch? I don't think we're on lunch. I think we're just on a break. Tune in if you know what's going on. Chime in. Chime in. Yeah, she wants to watch another witness and then testify again. That's what I hear. Okay. So back to craft time with Jackie. Freaking, I cannot. Guys, yeah, Judge Everett's like, I can't with this. I was trying to ignore most of it. But Selman asked her, did you attend a party at Wendy's? And she's like, yeah, actually, it was called How Wendy's Got Her Groove Back. Guys, the fact that Wendy has had a divorce party does not surprise me in the slightest. Okay, who was it? Hi, hey, you. This is messy. They can't get a mistrial. They're the ones that are freaking making this a mess. There's no saving Donna, whether it is by good means or by bad means. There's no saving Donna. Who, out yourself, who was the one who made the comment about Uncle Leo when we saw Wendy? Please tell me. Tell me. And then this was Brian. This was Brian's suggestion from yesterday. If you have any requests for art projects that you would like me to do for you, just put them in the chat and I will be happy to oblige. And this is when I wrote the highly sarcastic comment that not everybody got. Bang up job today by the defense team. Looks like you're going to win this one. As much as I hate to admit it, your preparedness, professionalism, and dedication to this case shows in everything that you do. Donna's lucky to have you. Reasonable doubt is in the air. I especially enjoyed the hour-long jail surveillance video. I think it was a poignant and compelling and really fought against much of what the state has been trying to prove. Others may talk down about you, but I say, au contraire. This team is succinct and focused and giving the state a run for their money. Sarah and Georgia, I hope you're paying attention. You could really learn a thing or two about this spectacular duo. I meant to type from the spectacular duo, but I was too deep in sarcasm to know what words are. Yeah, the jury's like, we've deliberated already. I know we're not supposed to. Somebody commented under this though, "Are you serious?" And I'm like, I don't know. I paired that with a picture of Jackie as a ventriloquist doll sitting on Zellman's lap. Use the context clues and get back to me. I'm not serious. The defense is a mess. I know, I was thinking that though after I posted it. So I said, this is going to get to somebody who doesn't subscribe to my channel and they're going to be like, what the fuck? Oh, yes. Hazel, it did it already. Please hold. Well, there's Harvey with everybody that we thought he looked like. They're identical. I posted it on Instagram and tagged Jeff Dunham. That was my first Instagram post.
All rise, they're entering the courtroom.
I'm so terrible. I can't I can't keep up with too many things at once, guys. Donna doesn't need to stand. The jury should stand for Donna.
Everyone can be seated.
I knew he looked like a puppet, but I couldn't.
Please continue with your examination.
The jury's starving, guys.
Miss Bailey, how did the Adelson-Markell divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markell's pleadings were drafted?
Yeah, I mean, he drafted pleadings.
How dare you?
Motions, I think, and responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language. But when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
so
but
isn't the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties, it's the most important thing in the world.
To some degree. That's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
derived.
To that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
It shouldn't have been. There was no proof.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markell wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
I think on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And Ms. Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that move to strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st.
Mm-hmm.
One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. There's no jail consequence to the $70,000 due Wendy. It was only the $10,000 due Kristen that could have possibly remotely been a possibility.
Did you
In
see
Florida, you can go to jail and lose your license
in this case
for not paying?
Of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own,
Gross.
and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled. The witness has provided an opinion. The state will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
Boom.
Can I have a moment to confer, Judge?
Go ahead.
Can I have a moment to take this mic off the podium so I can drop it? Thank you. Thank you. She even said teeth. Like, if you don't like our snark, we're just following Georgia, the queen of everything. Because she literally says teeth, and that was for a reason, and it was for more than just Javi being a dentist. Is that the back teeth of this proceeding? Oh, I am living for this. That's probably what happened in the first place, Harry E. She was mouthing off to the wrong person, and that tooth got punched to the back. Yeah. I'm living for all the defense's witnesses just for this part. For when Georgia gets up there and starts to do the destruction of Hurricane Georgia. Yeah, Georgia's watching the chat. Georgia's gonna say, hey. Somebody change your name to Georgia Kappelman. No, we don't want to get her in trouble. Hi, Okie Nanny. Seriously, this woman is ridiculous.
Redirect examination.
Let's
Briefly,
see.
Your Honor. Ms. Bailey, you sat through
He sounds
Kristen
defeated.
Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under your subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day.
If there's a place you need
Members
to
of the
go,
jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break.
The song I was searching for was Backpack, 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 Backpack. You know what's so funny is that yesterday Judy was like, there's this girl in the jury and she has like this tiny backpack, so she must be like young, like in her 20s, whatever. Hi, Stephen Krim. Now this lawyer comes up here with a tiny backpack.
Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioning the gallery again. I don't know what steps the court, needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is this coming over my right shoulder.
It's Javi.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Disclazo, I believe, is still to be called by the defense.
Yes, Your Honor. Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of your witnesses are present so we do not have any continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
Donna's in the courtroom. Sequester her. First of all, it is not lost on me the irony of him being all mad about the gallery is supposed to be quiet, and that is a rule of the court, but literally you've had now 2 witnesses sit in on other testimony. Like, guys.
Mom,
Guys.
what are these two? What are these two?
Those are the Golden Girls.
Oh.
I have a board book with the Golden Girls in it. The audacity. How about stop doing things that make the gallery gasp? How about that? Yeah. Joel is there. Steve, are you there today? Steve Sullivan. Stephanie, shouldn't they be trying to prove double extortion? Oh my gosh. I know. Well, that was Everett's clapback for him complaining about the gallery. He's like, why don't you make sure it's not one of your witnesses? Why don't you make sure that? Oh my God. Okay. So let's go ahead and put on a video. Did anybody hear when they're going to be back from lunch? Anyone? Okie doke. 2:15. Thank you. 2:15. Holy moly. I guess it's almost 1 o'clock. Never mind. 12:60. Hello, Conquer Your Fear 2. Okie dokie. Yeah, Georgia wrecked her. Well, her testimony was completely pointless and rude to boot. Disrespectful. Fancy Fiction snapped this picture, amazing, of Wendy the day she didn't testify. I need... What? I don't know. I'll help you find it in a minute. I need to see if the subscriber list has repopulated. Okay. So let's watch. All right, I'm going to put on this video because I feel like one of the main questions is why hasn't Wendy been arrested yet? And I explain it in this. Obviously, we're not going to be able to get through the whole thing today, but maybe we will be able to watch like half of it today, half of it tomorrow.
Never gonna get it, never gonna get it.
All right, let me back this up.
So, unless you're one of Wendy's 3 supporters, who are all Wendy on different screen names, I'm looking at you, Glenn, or should I say, Glendy. Try harder next time. You're wondering how she's spent 11 years free, or as prison folk call it, on the outside. Wendy is currently living in beautiful Austin, Texas, residing in a 2,784 square foot brick home that she is currently renting for $3,500 a month. Located 20 minutes outside of downtown Austin, this beautiful colonial revival home boasts 4 bedrooms and 3 bathrooms. An open, spacious floor plan makes this home the perfect spot for entertaining and relaxing. The gourmet kitchen opens up to a breakfast nook and is the perfect spot to eat your own words. The master bedroom features vaulted ceilings with plenty of natural light to keep up with your favorite books. Enjoy a bubble bath in your garden tub and lavish yourself at the double vanity where you can brush your teeth without getting shaken down for commissary.
So I was in the bathroom. It's 10:30 at night. I went in to brush my teeth.
Okay.
There are 3 sink stations in the bathroom. Each one has 4 sinks, and I was at the center station with my back to the door, and I'm a righty, so I was holding my toothbrush with my right hand, and I was balancing myself with my left hand on the sink. I was just brushing my teeth. That's all I was doing.
And what happened?
And someone came up behind me and pulled my left hand away from the sink and twisted my arm and like jerked it behind my back, like reaching up toward my neck.
Okay.
And
did it hurt?
Yeah, it hurt.
Okay. What happened?
It hurt. And I said, "What are you doing?" And she's, in the same breath that she did that with my arm, she said, "You're going to buy me commissary." I said, "I'm going to what?" And she said, "Unless you want those pretty white teeth knocked out of your mouth, you're going to buy me commissary." So I said, okay. And then she named a package that she wanted, and she's out. She was gone. She just that fast. That fast.
Okay. How bad would you, on a scale of 1 to 10, how bad would you rate the pain at the time that she did that to you?
Oh my God, it was a 10.
Okay.
I didn't know my arm could reach that far back.
Okay. And what did you do after she did that to you?
So, kind of stood there for a minute, and then I just thought, okay, I'm gonna go back to my bunk. And I went back to my bunk and I got under the covers and I cried. I just stayed under my covers. I didn't come out.
Okay.
And that is actually the house that Wendy is renting right now. And I truly hope that every morning she wakes up and takes a big stretch and remembers how nice and cozy her bed feels. So when she moves into her new place, care of the state of Florida, she'll be able to fondly look back on the life she could have had if she hadn't been a complete piece of human garbage. Too bad, so sad. So let's do a little review. Her immunity means practically nothing and will do zilch in terms of saving her. Now, you are testifying today under a state subpoena, correct?
Correct.
And that state subpoena gives you immunity for your testimony, right?
Yes. Can you explain to the jury, since you're an attorney, what immunity is?
Immunity is freedom from prosecution.
So that means that anything you say today can't be used against you if the state decides to arrest you later on.
The state isn't going to decide to arrest me.
Do you know if they consider you a suspect?
I don't know.
They do, bitch. And have since day one. But we'll come back to that.
Last thing you're going to get this afternoon is probably not what you want to hear, but it was a little legal lesson that one of the jurors raised. They asked a question about the type of immunity that was discussed by Ms. Adelson. It's really not a fact question, it's a legal question, but this is a little legal lesson. In the state of Florida, there are three kinds of immunity. There's transactional immunity, there's use immunity, there's use and derivative use immunity. Transactional immunity means that some person cannot be prosecuted for an offense. Use immunity means that what the person says cannot directly be used against them. Use and derivative use immunity means that what they say cannot be used against them, nor can it be used to develop leads to gather evidence against them. The type of immunity that Ms. Adelson has received, because I have been the one that explained it to her, is use and derivative use immunity. In other words, what she says today cannot be used directly against it, nor can it be used to develop leads against her. She does not have transactional immunity. I mean, she could be prosecuted for the crimes involved, but what she said cannot be used against her, nor used for any leads to develop information. So hopefully that answers the juror's question that asked the question.
Well, I'm sure it answered the jurors' questions, but our little Wendy Pooh didn't seem to understand. Because even though the judge himself explained it to her, she still said,
Immunity is freedom from prosecution.
Not for you though, bitch.
I said, bitch.
And then a mere 2.5 years later, she still didn't understand.
Ms. Adelson, where do you currently live?
I currently live in Miami Beach.
And are you here today pursuant to a state subpoena?
Yes, I am.
And do all state subpoenas confer immunity?
I don't know if all state subpoenas confer immunity, but this one does.
Okay, and do you believe that your subpoena is special or different from other state subpoenas?
I don't believe it's special or different, so I suppose they all carry immunity.
All right, and does the immunity conferred upon you by the subpoena mean that you can never be prosecuted associated with this case?
That's right.
That's what you think it means?
That's what I think it means.
Okay. And do you think, isn't it true that it's use and derivative use immunity? Do you agree with that?
Yes.
Okay, but not complete immunity from prosecution. Do you agree with that?
That's different than what you just asked before. So I'm sorry, can you repeat the question?
All right, so what I'm trying to allow the jury to understand is what sort of immunity you have. What is your understanding of what it means for you to have immunity pursuant to the state subpoena?
So I have derivative and use immunity. And so in the future, a prosecutor couldn't use what I say here today against me.
Correct. But you could be prosecuted. Just nothing you said here today could be used against you in that prosecution. Do you agree with that?
I suppose so.
Okay. Have you made any sort of special deal with the state attorney's office or with any law enforcement or government agent?
No.
Okay, I mean, we got there eventually, but this woman is a lawyer. It shouldn't be this hard for her to understand. And she uses the excuse that she isn't proficient in criminal law, and that's why she can't remember. But I think it's just like her insisting that Truscott is a shortcut. She thinks if she says it enough, it'll come true.
Is a wish your heart makes.
The government asked you about immunity, so let's get into that. You explained that as an attorney, you understand that when the government gives a subpoena for somebody to testify, that it conveys immunity. right?
That's my understanding. My knowledge of criminal law dates back to 2003 when I took a semester in law school. So forgive me.
Graduated law school, right?
This isn't my area of law.
When you clerked on the 11th Circuit, it was with Judge Jordan, right?
I did immigration appeals.
Yeah, but you still dealt with criminal stuff as well, too.
Very little.
So your understanding, though, is it doesn't mean they can't arrest you. They just can't use what you say here against you later on. So you're protected.
Correct.
And you needed that to testify, right?
It's just given to testify. It's not a question of whether I needed it. It comes with testifying.
No, you needed it. Wendy, you were standing right next to your lawyer when he told the court that you would refuse to testify if not under the state subpoena. We were all there.
John Lauro, and with me is Miss Adelson. Your Honor, as you know, Miss Adelson has been subpoenaed by the state as well as the defense. She, without a state subpoena, would unequivocally invoke her Fifth Amendment rights. We want to make that clear for the record. In light of Your Honor's prior rulings and direction, we wanted to put that on the record. However, with respect to the state subpoena, it automatically confers use and derivative use immunity on her pursuant to Florida Statute 914.04. That use and derivative use immunity would only apply to a state subpoena and not to a defense subpoena. So in light of that, we would ask respectfully that the court quash the defendant's subpoena, since there's no purpose and no appropriate purpose in calling a witness simply to invoke in front of the jury.
Let me ask you this, Mr. Laura. Any questions that are given to Ms. Adelson if she was called with the defense case, is she going to assert her Fifth Amendment rights to any question that's asked at that time?
Yes, Your Honor. I'm assuming any question would have to be relevant and germane to the matters in this case, and as a result, she would invoke as to those questions.
All right. And so I'm just going to assert my previous ruling that I've made, and I did restate it on the record yesterday, is that she'll be required to testify under the state subpoena. The cross-examination will be limited to whatever the state's brings forth on direct. So that's what the cross-examination scope will be limited to. There's no piggybacking or bringing in any other information just because she's under the state subpoena. That's not going to be permissible. And then she's not going to be permitted to be called as a witness. Now that we know that she's just going to assert her Fifth Amendment rights, she won't be called as a witness in the defense case at this time.
Yes, Your Honor. That's
Okay.
exactly our understanding of the law.
All right. Okay. Anything else for the court?
No, sir.
Okay. I'm going to ask that Ms. Adelson then please remain outside the courtroom because she's subject to the rule.
Yes.
All right. Thank you.
So you don't need immunity, yet you absolutely refuse to testify without it. Right. Got it. And your lawyer mentions the type of immunity you had not once, but twice. And no one's asking you general questions about criminal law that they expect you to answer. If that's not the area of the law that you practice, fine. But not knowing or pretending not to know what the details are surrounding your own personal immunity is ridiculous and irresponsible. Okay, let's get back to listening to Christopher DeCoste destroy you.
You fear being charged by them, so you need to have that protection of
I
your
don't
words.
fear being charged for a crime I didn't commit. No.
Now, y'all had this nice exchange where it was pleasant, but there's actually tension between you and this office, right?
No.
Hold on a second, Mr. Adams.
There's subpoena around.
You remain under their subpoena. Right to you.
Ms. Adelson has a flight tonight at 7 p.m. as she returned home and
But you can communicate with her about any arrangements if you need her to come back, but she's free to go at this point.
I know it didn't happen like this, but I always envision Georgia sticking her shoulder out to check Wendy as she walks by and then saying, "Did you just hit me? Huh? Don't play dumb with me. You want to go? I'm sorry." Meet me in the parking lot. We're having a lawyer cage fight. Sarah, hold my earrings. That would be my favorite. Okay, so we pretty well established that Wendy has no meaningful immunity that's going to keep her from getting cuffed. And just for funsies, let's watch Christopher DeCoste get her all riled up by telling her to just admit her guilt to the jury.
Now you need to ask a question.
Understood, Your Honor. If I could have one brief second to check with co-counsel.
She should get put away just for willingly drinking Aquafina. I would rather drink the slime off of a slug than put Aquafina anywhere near my mouth. He has already got her in such a state.
Miss Adelson, we started this by saying that this is all about you. It started with you because of this marriage, right?
No. Well, you tried to say that, but I don't agree.
These are the eyes of a mad woman.
Miss Adelson, I'm going to make one final attempt through questions to implore you.
He's giving you one more chance, Wendy.
You understand that you can't protect your brother Charles, who's going through this case, and protect yourself at the same time. You understand that, right?
I'm here to share the truth with you. I don't know how to answer the question.
Then please end the madness and share the truth. Will you please share the truth with this jury?
And the madness.
I've been sharing the truth since I walked in here. I've done nothing but share the truth.
You know what happened here, despite your claims to the jury that you haven't looked at anything, you haven't discussed with anybody, and you haven't confronted your brother. You know what happened here, right?
I do not know what happened here, and if I did, I would have shared it with the police 8 years ago.
And if she could scowl at you, she would, but her forehead has been paralyzed for just as long.
You know that your brother went behind your back, don't you?
I do not.
Like he always does. This is something that he has always done, isn't it?
Not.
You found out after that your brother had done this and gone behind your back. That's why you were thrown up at that dinner, right?
No, it's not.
You know that it didn't involve Katie either, right?
I don't know anything about...
If you're not going to say all of that and finally give the truth, why don't you just admit to this jury that you're guilty? Why don't you just admit to this jury that you're guilty? Why don't you just admit to this jury that you're guilty? Why don't you just admit to this jury that you're guilty? Why don't you just admit to this jury that you're guilty?
Because I'm not guilty.
One brief moment, John. I got nothing further.
Redirect.
Georgia, Sarah, and I mean this with absolutely no disrespect, but can we please just bring this guy to Donna's trial just to rile up Wendy before direct?
What's today's secret word?
Well, today's secret word is...
Would never.
I made my brother, the one, his name's Charlie, the one I'm really close to, he makes a lot of jokes in bad taste, and it was a joke he made. He bought the TV for me this morning that got broken, and I was talking to him about whether it made sense to pay to fix it or whether I should get a new one, and it was always his joke that, like, he knew Danny treated me badly, and it was always his joke. He said, I looked into hiring a hitman, and it was cheaper to get you this TV, so instead I got you this TV. I mean, he would never... He's my big brother, and he's been taking care of me since I was little, but he would never. But even my family, who felt like I had been mistreated, would never do something like this. Never. You know, my parents are very angry towards him. But even when they're around my kids, they would never say a bad word about my kid's father. They're really, really careful about that. They just like him, but they know he's the father of my kids. They would never do that. My ex-husband caused me a lot of grief. I would never do something like this.
Time for a breakdown. Never gonna get it, never gonna get it. Never gonna get it, never gonna get it. Never gonna get it, never gonna get it. Never gonna get it. Whoa, whoa, whoa.
Would never as code for definitely did. Wendy told Isom over and over that she was a suspect during this interrogation.
I understand why you think I'm the primary suspect.
No, you're not the primary suspect. I have, and it's
so
gonna.
I understand why I would be the person you would think would do something. But,
well, we have to.
And I get why I would be a suspect, but I can see why they would think it would be me. And then I was thinking, oh my God, now they probably think I'm a suspect. I should.
But of course you're a suspect, and you're a smart suspect. You should be the suspect.
I'm assuming I'm a suspect. Do I need to be read my Miranda rights or something if you're gonna look at my phone?
I can read your Miranda if you want to hear that.
I don't know. I'm just trying to make sure I'm being.
I have no reason. I have no reason at this point to suspect you in this incident. Okay.
I couldn't tell from the way you were talking to me in the car if I was a suspect.
Well, no,
I understand why I'm a suspect. I guess I'm not a suspect. I understand why you would think that I would do this, but not you. But
right.
I just keep feeling like I'm a suspect, and I need to am I a suspect? You need to.
Fuck, confess already.
Why don't you just admit to this jury that you're guilty?
I always wondered if Sarah, the victim advocate, knew that Wendy was a suspect. And I've always had the sneaking suspicion that she did. But then I found a clip that confirms what I'd been suspecting all along. It's towards the end of the night, and it's one of the last things she ever says to Wendy. And watch Wendy's reaction when she says it, because she picks up on it immediately.
They're like, you need your work computer. I'm like, work? Take my computer. There's nothing on it you're going to find that's going to... Well, I don't know. Maybe there's something they'll find that's useful, but...
Well, they're used to thinking. A lot of times things will happen like burglaries, or they deal with suspects who aren't cooperative and don't, they're like, give me my stuff back. And
yeah.
You've been a super cooperative suspect, Wendy. And you know what? Because you were such a big helper. You get to pick out a super special sticker all by yourself. Which one? That one? Wow, Wendy.
Wow,
Great choice, Wendy.
Wow.
I want to slow that part down so we can watch Wendy's body language change as she completely dissolves into her chair, defeated.
burglaries, they deal with suspects who aren't cooperative and don't, they're like, give them my stuff back. And
yeah.
Before.
Take my...
Smiling, lighthearted, animated, confident, direct eye contact. After. Head down, closed off, holding her neck to protect her carotid artery. Sighs of sadness, completely shut down and not talking. I think Sarah did her best for the most part. I think she was brought in there mostly to keep Wendy talking and to keep up the ruse that she was a victim. I feel like she was definitely picking up of most of the off-putting comments Wendy was making. And there were times that she was visibly uncomfortable due to those comments.
Oh my god. Well, my parents sounded really surprised, so it's at least a relief. I was trying to think of who would be angry enough to do something to him. My parents would be angry, but they're not capable of this. Thank God. I really couldn't handle that right now.
Yeah, no.
What an absolute bonkers thing to say. Well, it sounds like my parents weren't the one who killed him. Probably, perhaps. They're definitely pissed enough, and I'm clearly telling you that they're most certainly capable of this. But it doesn't sound like they have blood on their hands right now. I couldn't handle knowing both my parents and my brother Charlie and me myself all conspired to kill Dan. I mean, we did, but geez, I've got enough on my plate. I have to pack for my move to Miami. JK, I already did that all week, actually. I'm a planner. The way she looks to Sarah for some reassurance in response from that absolutely unhinged dumpster fire of a monologue is beyond insane. And poor Sarah, clearly dumbfounded, can only manage
Yeah, no.
So Wendy, that's what we call an inside thought. Those ones stay in your brain. I know it's tough, but if you really feel like you just can't hold it in anymore, you can try to write it down in your journal or take a little walk into the woods and tell it to a kindly little frog. But when we're in a police station as a suspect for murder, it's maybe not the nicest time to say something like, my parents more than likely killed my ex. Jeff also spoke with her after the murder and reported on a few odd occurrences. Well, Jeff was a treasure trove of information, but I just wanted to touch on a few of his revelations.
Okay. All right, I got the men that you're talking about. She made, well, first of all, does she still have the same phone number?
She switched her phone 3 or 4 days after the shooting because she thought you guys had bugged it.
Okay. All right, do you have the new number?
I don't. I think she has the same number. She has a different phone. She just wants
a different handset?
Which is silly because you don't need to put a bug on a phone physically. Right. I mean, it's funny.
Why would she be concerned about people bugging her phone, or the police bugging her phone, I guess is what she's specifically concerned about?
She's real concerned about that. She told me that.
Did you ask why?
No, I knew she was.
Okay, let's assume for a second that Wendy was innocent. Because technically she is before being proved guilty in a court of law. Even though the case is closed in the court of public opinion. And we all know what my opinion is. But under the assumption of innocence, why would an innocent person who had just learned of her ex-husband's passing find it necessary to buy a whole new phone over fear that the cops had bugged your last one? A normal innocent person, who Wendy claims to be, would have nothing to hide. Also, who Wendy claims to be.
You don't realize that you could be helpful in finally untangling this to give this jury the truth about what happened to Professor Markell?
I have been nothing but helpful since this started.
So what happened to their son? By you looking at it, you are at the center of all this, but you won't look at anything to help in the process.
I've done nothing but help in this process.
You came here and testified.
I came here and testified. I spoke to the police for 6 hours without anyone present. I signed over my cell phone, my car, my house, everything, my computer. What else do I have or know that you haven't seen?
And then promptly got rid of my house, my cell phone, my car, my computer. What else do you want from me? I'm an open book. Because if you were innocent, there would be nothing that the cops would see or hear that would put you in any sort of jeopardy to warrant you getting an entire new cell phone.
You're guilty.
I immediately thought she did this, and so she told me 50 times, Jeff, I had nothing to do with this. And I always just let it be silent, I just let it be silent because I didn't want to go there. I didn't want to play my hand. I've never said anything to her. I just wanted to listen. I was hoping she might give me something interesting and I would come tell you guys. Because she's erratic enough, I thought she might say something stupid. She must have said 50 times I had nothing to do with this. And you
Okay, let's do a brain exercise together. Think back on the last time someone that you knew passed away. Or if you haven't experienced that, think back on a time when a celebrity has passed away. Do you find it necessary to go around telling everyone over and over and over that you swear that you had nothing to do with the death of Biggie Smalls? R.I.P. B.I.G. No. And you know why? Because innocent people don't even consider the notion that someone might think that they did it. Because it's a given. It's assumed. Of course you didn't do it. You don't even think about maybe having done it. But Wendy knew that she was a suspect. And not just because she's the ex-wife, but because she had such a guilty conscience. The real question is, how soon did the cops consider her a suspect? Well, I happen to have some documents that might shed some light on the subject. In a supplemental report written by Scott Cherry, he records the following. I was first tasked with drafting and securing a search warrant for the crime scene as the house was still in the name of the ex-wife, Wendy Adelson. It was learned quickly on scene that Markell and Adelson recently went through a nasty divorce. A search warrant was reviewed by Judge Fleury and executed subsequently. So the moment they got to the scene, they learned that the house is still in Wendy's name and look into the divorce records and show their contentious, nasty relationship. So to answer that question, I'd say immediately. Officer Cochran then speaks to Mr. Geiger, who informs him that Dan and Wendy are recently divorced and have 2 children together. As the incident had just occurred, I was tasked with traveling to Adelson's last known address, 3303 Aqua Ridge Way, to conduct surveillance. Upon arrival in the area, I remained stationary with a view of the front of Adelson's residence. During my time on the scene, I did not observe any activity at Adelson's residence. After approximately 1.5 to 2 hours, I was advised that Miss Adelson had been located and the children in question had been accounted for. I was advised that I no longer needed to surveil Adelson's residence. Note, he didn't say he went there to deliver the news. He went there for surveillance. All right, so TPD arrived at Dan's house around 11:30. So, accounting for the time that it took this officer to speak to Mr. Geiger, we can estimate the time he would have left to go to Wendy's house, maybe between 12 and 12:30.
So it makes sense that you might have left your residence at about 12:30?
Sure.
Okay.
Meaning he just missed her leaving. Because it would make sense that Isom would be the one to both assign him to Wendy's house and pull him off when he himself got to Wendy. Which, with her interview starting at 2:45 and the police department only being a 10-minute drive from the site of Mosaic, the timeline lines up pretty well for him arriving to her house for surveillance around 12:30, as it's about a 15-minute drive from her house to Dan's house. And as we know, the time that Wendy left her house...
Okay, so it makes sense that you might have left your residence at about 12:30?
Sure.
Okay.
So that all lines up. But I found that a very interesting piece of information that Isom sent an officer to post up at her house. And then, as we've also learned, he gave another officer a description of Wendy's vehicle and posted him on the perimeter of the crime scene, should she pull up.
And then you go and then you kind of block off traffic coming down Trescott, right?
Yes, sir.
Were you asked by any of the investigators to provide a log of any vehicles that were attempting to come down Trescott?
Not a log of vehicles coming down.
And by that I mean, like, nobody asked you to observe which cars were coming and turning around, right?
Not specifically which cars were coming and turning around now.
Did you have a notepad with you in your vehicle?
I always have one with me.
Did you take notes of which vehicles came down Trescott and turned around?
Only the one that was of concern.
Okay, and you took a specific note with regards to this vehicle?
It's in the report, sir.
And what did you write?
Basically that I'd seen a vehicle matching that of the description known to be driven by the ex-wife.
So you knew, when were you told the description of the vehicle known to be let me rephrase that. Sorry, I'm all over the place. So you knew going in what Miss Adelson's car looked like?
At some point after arrival, I was made aware of what
her vehicle looked like?
Yes, sir.
And this is before you got in your car and you posted up and did your job to create a perimeter, correct?
It may have been right beforehand or while I was sitting there. That I can't recall. It's been a few years.
Understandable. Once you saw the vehicle that you believe matched her vehicle, did you get on your radio and say, "Hey, somebody go ahead and pull Miss Adelson over"?
No.
At that point, did you know that she was an ex-wife?
From what I'd been told on scene, it appeared that there was a separation or split or something. I couldn't have stated that conclusively at that point, though.
You have the ability to get on your radio, correct?
Yes.
Okay. And there's other law enforcement officers, I assume. You said there's 4 cars at the scene, right?
Yes.
Okay, there's a crime scene van there?
Yes.
There is no lack of law enforcement to be able to assist you to pull this vehicle over and inform this woman that her ex-husband had been shot twice in the face, correct?
As far as what I knew at that point, we didn't have a reason to stop her. I was just told, be on the lookout for the vehicle. And I had notified the investigator that I'd seen a vehicle matching. And, that's all I can tell you about that part of it. They told us to keep an eye out, saw a vehicle that matched it, and I just let them know that I did see a vehicle that looked like it.
Well, but you understand my question, right? Because
yes.
Your testimony, officer, is that it appeared that this van, which had clear view of her ex-husband's house, right?
Yes.
Because your testimony is assuming to this jury that it was Wendy Adelson that was driving that car, right?
I'm sorry, say that last part again?
Your testimony, or what you're suggesting to these jurors, is that may have been Wendy Adelson in that maroon color in this vehicle, right?
Correct.
Okay. And so your testimony was also that when the car came, the person didn't stop and ask you what's going on, right?
No.
The person didn't get out screaming, "Oh my God, that's my ex-husband's house," right?
No.
And you would agree with me that may be considered a normal response to seeing law enforcement and crime scene and EMS and somebody that you had a relationship with, that's their house, right?
Quite possibly.
So the normal response would have at least been to inquire, correct?
I can't say what her normal response was because I don't know what her role exactly was.
Okay, well...
Did you catch that?
You would agree with me that may be considered a normal response to seeing law enforcement and crime scene and EMS and somebody that you had a relationship with, that's their house, right?
Quite possibly.
So the normal response would have at least been to inquire, correct?
I can't say what her normal response was because I don't know what her role exactly was.
Okay, well...
He can't say what a normal response from Wendy may have been because he didn't know what her role was. Murderer. I.e. if she was a victim or a perpetrator. Because I think most of us could agree that a normal response from someone pulling up to a crime scene at a house where their kids were that morning would get out and inquire at least. But the killer would have a very different reaction.
Let me ask you this. The car in question didn't stop, right?
No, sir.
Okay. Didn't stop to inquire to you as to what's going on, right?
No, sir.
Didn't get out of the car?
No, sir.
Didn't ask you any questions?
No, sir.
Okay. And pretty smoothly made a 3-point turn and drove away, right?
Correct.
And when you had to turn around at the tape, right, to go back out?
I think I tried to turn right and it couldn't turn, so I would have made like the kind of turn, like a K turn, and kept going.
Was there a roadblock there with...
There was tape.
Yeah, and an officer was there?
I didn't see an officer, but I did see a car.
A law enforcement marked vehicle? Okay. Did you have any contact with the officer?
No.
Okay.
I just want to
clarify that when you observed the vehicle that you saw approach the crime scene tape, was it your responsibility for finding and interviewing Ms. Adelson, or was that the responsibility of some other officer?
Somebody else.
Okay, and you notified who you thought to be the correct person of what you had seen?
Yes.
And did you do that immediately?
It was right around that same time frame. I called him on the phone.
All right, no further questions.
In a supplemental report written by Detective Isom, he states the following. Wendy Adelson is the former spouse of Dan Markell. It was learned that they have 2 young sons together, and the children were at daycare when this incident occurred. Wendy's name was still assigned to the City of Tallahassee utility records at the incident location. It was determined that Wendy was residing at another location, 3303 Aqua Ridge Way. During the on-scene investigation on July 18th, it was determined her probable location was at the Mosaic Restaurant on Market Street. As there were no other known family members locally, I went to the Mosaic location in an attempt to contact Wendy. I entered the business and announced my presence and intention of contacting Wendy Adelson. She was seated with 2 other women at a table and acknowledged that she was Wendy Adelson. I identified myself with the police credentials and asked that she accompany me to TPD. Wendy appeared distraught and inquired if something had happened to one of her children. I assured her that the children were fine and this event was concerning her ex-husband. Wendy was apprehensive, but agreed to travel with me.
So remember just now when she tried to say, oh, well, they told me in the car that he had been shot. And she only said that because Georgia had literally just pointed out, hey, remember when you said that you thought you were a suspect in the car before you knew Dan was shot? Remember that, remember that, remember that? And at first, she's like, they didn't tell you anything, did they? They just told you that it was something concerning your ex-husband. And she's like, I don't even think they told me that. Like, they gave me no information whatsoever in the restaurant or in the car. And then Georgia's like, so remember when you said you were a suspect before you found out that Dan had died? And she's like, oh, they told me in the car that he was shot. Blah, 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 blah.
To Tallahassee Police Department.
2 friends that I was with for lunch when they came and found me. How did they find where I was?
I have no idea.
I mean, did they just search for my car? Like, I am just amazed.
And my theory, which I feel has been confirmed by Officer Brannon, is that Isom assigned someone to follow her after she sped away from Truscott. Shortly after Officer Courtroom left Wendy's residence, he traveled to ABC Liquor to confirm her purchase of Bullet Bourbon, and then executed a warrant on the following cell phones: Wendy Adelson, Dan Markell, and Charlie Adelson. And this is different from the Cellbrite extraction that they did on Wendy's phone. This is a warrant that grants cell and text details directly from the phone company with no physical handset needed. Court orders were secured for cell phone data from Markell's cellular account as well as Wendy's account. In addition, court orders were obtained for the cellular accounts of Wendy's parents, Harvey and Donna Adelson, and her brother, Charlie. The court orders were provided to the TPD Technical Operations Unit Supervisor Sergeant Corbett for submission and returns from cellular companies. The data did not initially give any obvious information to assist in this investigation. It did show that Charlie and his parents, Harvey and Donna, were in Tallahassee at the time of the murder. Officer Cherry writes, I was provided copies of Wendy Adelson's email accounts and reviewed them in part at the request of Investigator Isom. I viewed her email accounts set up for an online dating site and her Gmail account from all that was captured of 2012 July through September of 2013, and April through June of 2014. And Dan's postmarital relationship was very adversarial and very impersonal. They were both concerned about the children, and this was the basis for most communications. Wendy vented her frustrations to her friends and mother about the hardships in dealing with Markell and the divorce and custody issues. It was very clear that she wanted to move to South Florida to be closer to her family. So straight away, investigators were reviewing her phone data, calls, texts, and emails. So regardless of what she was telling Isom about her and Dan's relationship, he was able to see in black and white that she was not being honest in her account. So this, paired with the knowledge that she had showed up to the crime scene, behaved differently than any other vehicle that had pulled up that day, and was lying about how her and Dan got along, there's no way the red flags weren't flying. From the very first documents reviewed, they learned the following. She filed for divorce September 10, 2012. Markel reportedly returned home from a business trip to find his family gone, a majority of the contents of the house missing, and the paperwork for dissolution of marriage displayed on the bed. He eventually learned that Wendy and their 2 children had moved to her parents' home in Coral Springs. Markel protested and Wendy returned to Leon County with the children until legal arguments could be heard. Her parents, particularly the mother, were very involved with trying to facilitate the relocation of their daughter and grandkids to South Florida. In June of 2013, a judge formally denied her motion for relocation with prejudice. After this ruling, her mother, Donna Adelson, sent emails to Wendy with suggested tactics that she could coerce Markel into agreeing to the relocation of their children. This included offering Markel a large sum of money and photographing the children in front of a local church, that the boys were being taken to a Christian place of worship rather than a Jewish synagogue. Donna even suggested for Wendy to threaten Markel that she would have the boys baptized in the Catholic Church. This suggestion was in spite of the fact that Wendy and the Adelsons are also Jewish. Not included in this is the part where Donna suggests that they dress up the kids in Hitler Youth uniforms like little toddler Nazis. This family is bonkers. The threats that they were suggesting were akin to a child not getting their way, so they tell you that they're going to hold their breath until they do. Brats. They're brats. That's all I'm trying to say. There's also a report from Isom about his interview with Wendy, and these are the things that he highlighted. Wendy received a voicemail from an associate while waiting in the interview room, informing her of a police incident at her ex-husband's home. I confirmed that her husband had been seriously wounded by gunfire. Wendy broke down emotionally. She then composed herself immediately and provided an account of her activities for this day leading up to Mosaic, where I contacted her. She could not provide a possible suspect that had been feuding with Markel and discounted Markel of having any criminal associates. They were separated in 2012 and divorced a year ago in 2013. They share custody of their 2 children, and Wendy said that she was out of town visiting her parents from June 30th through July 10th of this year. Wendy stated that she has lots of friends and surmised someone may have committed this act, believing it would somehow help her. She then stated at 3:08:45 p.m., her brother Charlie makes a lot of jokes in bad taste and told Wendy he had looked into hiring a hitman but found it cheaper to buy her a TV. She referred back to the morning conversation with her brother Charlie over the phone concerning a TV that he purchased for her that was now broken. Wendy did not believe Charlie or any other member of her family would actually be involved in this crime. Wendy said her brother is a dental periodontist in South Florida, and she stated that after the divorce she wanted to relocate to South Florida with her children and felt that her former in-laws would suspect her of this crime against their son since she was denied the ability to move with her children by the court. Wendy was asked about the punishment of someone convicted of this crime should the defendant be known to her. She answered the person should be prosecuted to the full extent of the law, unless it was someone in her immediate family, which she does not believe is the case. She does not suspect her brother Charlie would be capable of this crime. At 7:03 p.m., Wendy wanted to call her parents and notify them of the incident. While contemplating aloud what she would say, she told the victim advocate, seated beside her, her parents were very angry with Dan Markel and described it as a very fucked up situation. Wendy then called and talked to her mother. After notifying her of the shooting, she asked her parents to travel to Tallahassee from their home in Broward County. At the end of the conversation, Wendy tried to catch her mother before she disconnected. Her mother immediately called Wendy back, and Wendy asked her to notify Charlie of the shooting so she wouldn't have to make a separate call to him. Yeah, and she probably didn't want to make that call to Charlie because he would say, "finally," loud enough to be heard by the victim advocate.
They're very angry with him, right? Like, well, this isn't like it's their son, but he's the father of my kids, and this is a very, pardon my language, fucked up situation. Okay, I'm gonna call my parents. Okay. I have no idea what to say because I don't even know that he's dead.
And if I can't tell them for sure that he's dead, then we spent all this money for nothing. What? What? Nothing.
Hi, Mom. How's it going? Mom, I need you to sit down. I am fine. The boys are fine. I need you to sit down. I'm fine, and the boys are fine. Danny has been. You can put me on speaker. Yeah. Danny has been shot.
What? What?
And I don't think he's gonna make it.
It is a fucked up situation. I think anyone who's willing to snuff the life out of someone who gets in the way of their misguided plans are pretty much fucked up. So one of the main questions is why, if Isom had this much intel at his fingertips, why wasn't he harder on Wendy? Isom is a seasoned investigator, and he went with the catch more bees with honey approach, even knowing that Wendy was a murder hornet. He knew that if he came at Wendy in an accusatory tone, that she wasn't going to hang around for very long. And with the likelihood being slim to none that Wendy would have confessed anything, his best bet was just to make her feel comfortable so he could keep her there as long as he wanted to. Getting every shred of data off her phone and letting her act completely off-kilter the whole time. He didn't get a confession, but she said a lot of incriminating things and acted in ways that were completely inappropriate for the situation.
Okay, but he might make it.
I don't want to give you that false hope.
I'm sorry, I just thought he was gone, and now I don't know what to tell. It's sort of a game changer.
I know, and then when, something like this happens, they do go to the hospital.
How did this... So, when it happened, did someone call the police because they heard a gunshot or something? How would they know did he call the police? How would they know to take him to the hospital?
I don't know the answers to all these, and I'm not, I'm gonna let, when Investigator Eisen comes back in here, I'll let you kind of ask some of those questions.
Okay.
Okay. But I didn't want you to think, I'm sorry, I just didn't want you to think that he was
I thought he was gone.
And that's what I was getting from your conversation, and I didn't want it to be...
If he's still alive, I need to make different choices. Right. I want the boys to be with him. Well, I don't know. I mean, if he looks scary, then...
Right, and that's what...
Is that why? Does he look scary? Is that why?
I don't...
So, with all this evidence against Wendy, why hasn't she been arrested yet? So, I think there's multiple answers to this, so let's go over them now. Problem number 1, Willie Meggs. Willie Meggs was the state attorney for 30 years. He was the first major roadblock on this journey to justice. As followers of the investigation of the murder of Professor Dan Markell will recall, State Attorney Willie Meggs has been proceeding with caution in the case. Even though some of his colleagues in law enforcement allege involvement in the murder by the Adelsons, the family of Markell's ex-wife Wendy, Meggs has so far not approved any prosecution against them. And the Adelsons, through their lawyers, have maintained their innocence. Meggs even offered this sassy comment: if the police believe they have probable cause, then they can go ahead and make the arrest. They don't need me. I would say to Chief Michael DeLeo, go make the arrest and get ready for your civil suit from whoever they've arrested without probable cause. So it seems to be that one of the paramount reasons for not prosecuting the Adelsons was a direct threat to bring civil suits against any and all offices involved if any attempts were made to go after the Adelsons. And that sounds like it came right out of the horses' mouths. David Lapp from Above the Law even looked into whether or not the Adelsons had made a contribution to his campaign. And even though he couldn't find anything, I don't think that bribery is above them in any way. And I also don't think that they would leave a paper trail for this. Meg said disagreements between his office and police investigators continue, but until police gather more substantial evidence that can be proven in court, there would likely be no more arrests in Markel's killings. And this article was written in the time period between Sigfredo Garcia's arrest in May of 2016 and Katie's arrest in October of 2016. Officers can arrest Meg Banawa or the Adelsons without a warrant because they face felony charges, Meg's added. Police interpretations of the evidence are the problem, Meg said. It's what investigators say, not necessarily what the evidence shows. Making the jump from theories to formal charges is a big leap. If they believe that someone said something and we're supposed to adopt what an officer thinks and arrest somebody, that's not the way it works, Meg said. After Meg's decline to approve probable cause for the arrest of Meg Banawa and Charlie Adelson, sources in the state attorney's office confirmed that TPD began seeking out the authority of the U.S. Attorney's Office for the Northern District of Florida. Katie McManawa was arrested 3 weeks after these statements were made. And although I was able to procure the arrest warrant signed by the judge, I wasn't able to find concrete proof of who exactly gave the green light on the warrant itself. Here's the warrant for Katie's arrest. And this was signed about a week and a half before her arrest by James C. Hankinson, who presided over both of Sigfredo and Katie's first trial, as well as Katie's retrial. So, although it's unclear whether or not he ended up signing off on Katie's arrest, he was quite clear that none of the Adelsons would ever be charged in relation to Dan's death. After reading the probable cause affidavits for both Charlie and Katie, Meggs categorically said that there was absolutely no evidence or probable cause to make any arrest, a stance that the Adelsons publicly applauded, with Charlie's lawyer at the time, David. Mr. Meggs has spent the past 40 years as a prosecutor, with 30 years as a state attorney, and before that was a decorated police officer. He is one of the most experienced state attorneys in our nation, and he knows probable cause when he sees it, Marcus said. We are thankful that he faithfully and honorably fulfilled his duties and did not approve this document, which amounted to no more than simple speculation after a truly exhaustive investigation. The Adelson family previously released a statement denying involvement in the slaying. Any speculation to the family's involvement is categorically false. That aged well. After Meg's retirement in December of 2016, the investigation was full steam ahead. The Dolce Vita tape was certainly some of the most important evidence against Charlie. And although it was able to be heard and transcribed by investigators in 2016, it wasn't made clear enough for a jury to hear this until several years later. This was truly the tipping point to bringing Charlie to justice.
Sir, were you asked to clarify recordings in reference to the case State of Florida versus Charles Adelson?
Yes, I was.
All right, I want to start with the Dolce Vita restaurant recording. What items were provided to you in reference to that exhibit?
I received 2 recordings, one from each device that was deployed in that restaurant.
All right, and was one better audio and one better video?
Yes.
All right. And what's the part that's of interest to you?
The audio.
Okay, and so you don't do anything with the video?
Only used it for observational timing reasons.
Okay. And was the bag that had the mesh on it, was that the one that was the better audio?
Or the
Yes.
one that had the better video?
Right. The one with the better video had very poor audio, and the one that had better audio had very poor video.
All right, I'm with you. And the one where we're looking through the little holes, is that the one with the good audio or the good video?
The good audio.
All right. Can you sort of walk through the process for the jury of how you clarify an audio that has a lot of background noise going on?
Yes, our technique is a bit different than other techniques in that we take the audio and treat it like it's an image, like a photograph that's out of focus, it's blurry. And so we read it into the computer and figure out how to unblur the sound, just like you would unblur a photograph. And this fortunately has the nice effect of focusing in on the person's voice or the people's voice if they're near each other, and blurring out the rest of the background, sort of how you would use a video lens if you're a photographer, and you can zoom in on a person's face, but everything behind the person and everything closer is blurry and kind of pushed down and not as noticeable.
Were there any particular issues or problems with this audio?
It was frankly a mess. Competing voices, loud noises, movement of both devices, not good positioning. There was a kitchen, and of course it's a busy cafe, coffee grinders, blenders, order taking, lots of different sounds going on.
All right, and can you tell the jury that the most up-to-date efforts available in your field were applied to this exhibit to make it as good as possible?
They were.
All right, and what was the outcome? I think you've got some different segments. Could you tell us about that?
Yes. Fortunately, the recording device that had the better audio was also the one that had the longest audio. The recording started at different times. One device arrived into the establishment significantly prior to the other one. I believe it was like 20 minutes difference. The one that started first, its recording first, moved. The person carrying it came in from the outside, came to the counter, then went to a seat, and then moved to a different seat, getting better position. And each one of those changes of location causes the focus to change, just like you were taking a picture. All of a sudden, the person you're trying to take a picture of moves, you've lost your focus, and you have to regain your focus. Also, a limitation of our tool limited the sheer amount of audio. It's a huge amount of recording, and so we had to break it up into portions, segments, which we did the beginning, the middle, and the end. And we worked with the FBI agent to break it at about the same points that the motion happened of the recording device.
Okay. And have you had an opportunity to examine State's Exhibit 110 thumb drive?
Yes, immediately before we came in here.
All right, and is this a fair and accurate work product that you did as far as the audio only on the Dolce Vita recording?
Yes.
Okay.
And as much as they were able to clean up the audio, I was able to clean it up even more.
It would have already not done it for us. The problem is, even if they bought this, even if they bought your whole phone, you still get no money. And even if they bought your phone, depends. You're about to hate it. And they bought your phone, they're not without anything. So my point is, how do you get people to talk? You put a smoke grenade, and then you get all the cockroaches to run out. There's smoke in the house, smoke in the house. And everyone's running and everyone's talking. And you throw a smoke grenade, what do you think? If that's what it was, it's very smart. Because my mom had a salt my dad, and my dad's going to flip out when he finds it. But my mom hadn't told my dad anything. But normally, obviously, if that was a cop that came from someone, that night, when she comes home from work, she would say, "Yes, I got money." And she paid me a little visit when I'm taking the grandkids to school. And then, after I dropped them off, she was walking home. And she dropped them off, and I was walking back by herself. So this person had to be with the thing is a lot of times my mom takes the car, drives to the school, the kids, this person, her routine, knows who she is. Yeah. Someone may have come to the office. My dad works Monday, Wednesday, Tuesday, Wednesday, like, you know, he'd probably either get him on the beach or get him at the office up there. And they may have approached my mom because my dad maybe some less carries a gun. So you never know. So, you know, you don't want to turn into a fucking shootout. I mean, I can say a lot about I carried on me. I mean, no one comes up to me. You carried on you right now? I mean, I'm going to start carrying one on my back. Like, you know, the holster that fits in your back. Someone comes up to me, they're going to be ready to shoot. I'm going to shoot. Someone comes up to me asking me for money in my house. Yeah, and guess what? When the fucking police show up and there's a doctor or the oral surgeon standing there with a dead gang member in the fucking driveway, they're not going to come down too hard on me. I'm not going to talk anyway. I don't know much. I don't trust them. It's just not like some chick showing off tattoos to your man. Like, this is actually serious because these people are going to come back. They didn't go through the trouble of seeking my mom out to use that and then go away. So I got two options. They're not going away. And they wish they'd go away and never come back. They ain't going away. The trouble they wait. Well, with the beard or with the badge? Well, I don't listen. If the badge comes up to you, tell them have a nice day, officer. Listen, if they want to charge you with something, charge me. If not, I don't talk to cops. Sorry. No, it's very simple. It's like, if you're gonna charge me, charge me. Yeah, but things have changed a lot, though. You know what's changed a lot? There's cameras everywhere. So cops now, they have a fucking pension. When they retire, they're going to get a pension for the next 30 years, medical, dental, and a salary every month. If they think that, you know, the camera, look, how many cameras are in here? 5? You know? I mean, they better be doing it in a place where there's not a chance that someone doesn't have a camera pointing outside the building that captures it or their dash. What I'm saying is that this person is not going away. And they came very equipped with details. Where do the details come from? I don't know. The details I don't know. Well, because one of the things, you go to the cops, you get information. To put them in the scene and the date. The guy's name was Tuco. I don't even know who the fuck it is. This is Tuco. Tuco's person. And I know that you can help it out. Your family can help it. And her family. Now, Tuco's family needs your help. I was like, I don't know what you're talking about. And he goes, well, maybe this will refresh your memory. I handed it to her. What? Make me think. think they don't treat people the way to a farm story, where they think how bad. Well, let me ask you a question. When everybody was there, but it's not like you're driving around in a Bentley, cruising around a mega yacht, you know. You must have that something at some point. Otherwise, you'd have no idea things. That's why. Oh, wait, no, it's open. Yeah. Well, you can know something, but not any. The problem is this thing. Okay, so this, you'll tell the cops. They're going to ask you, where's the weapon? You're going to say, I don't know. You know who? Say name. Okay. Did you witness it? Just say no. If you didn't witness it, you only heard a rumor on the street that this person did something. You know what that's worth? 0. Then what you do is you wear a wire, get this person talking, and if you can get the person to confess on wire, then you have something in your charge. You have a confession. Outside of that, there's no evidence. Okay? If you have a car and you can link this person to renting that car that you the crime, okay. But you have to prove that they were also driving that day too. They didn't rent it and then lend it to a friend. What if you rented a car today? I go, Katie, can I borrow for the weekend? I'll bring it back on Tuesday. You go, yeah, sure. So you rented a car. You've been in that car. I drive it to fucking Orlando. I rob McDonald's in Orlando. I come back and I go, here's the keys, Katie. And we go, okay, thanks. Yeah, you rented it, but. Or what if you were fucking out all weekend and you didn't even know I took your car? I did something and I brought it back. Okay. My point is I don't have any knowledge of what went on. Evidently, this person's either pretending to or does. I don't want someone paying for this for the last years. I wish it was cop playing games. Why did it know this? It was a cop playing games or an investigator playing games, and they didn't mention me. They didn't mention their son's girlfriend. Not mention me at all. And my family. And I think if they thought I had something to do with it, they would find me and talk to me. You know what I'm saying? Like, go talk to the person who's involved, not talk to the people who are involved. And I'm not involved, but if they do our view, they should not my family. But in my case, not my mom, my dad's age. This person obviously doesn't know that he's 18. That's the right action. Who was the boyfriend? The 71-year-old guy? Not very much. Or the 37? Yeah, oh. Not waste your time with Marvel. They need to talk to So, wouldn't it make sense that you're connected to my family? You're connected to my family is not my mom. Like, yeah, you work in the office now. And that's just because you come in and work on the weekends, which I can cross on your know. You come every day when I see you. tell me, dude, the place is clean, so you get your check. You clean up, whatever, but that's neither here nor there. The person that knows information, so even if they are a cop, they're speaking that information. Says years. And they also know that they're claiming that somebody had something to do with it, is incarcerated. I don't know anything.
All they need to do is record a confession on a wire, he says, and then proceeds to immediately confess on the wire.
You are so dumb. You are really dumb. For real.
Let's get back to Wendy. One of the biggest reasons she's not been arrested yet is because the state has used her as a witness in every single trial so far. And she is a great witness for the state. Not only does she sit up on the witness stand as if it's her own personal throne, but the smugness and casualness that she answers these questions are extremely off-putting for the jury.
The state isn't going to decide to arrest me.
Not a good look. Because not only is the jury to listen to what the witnesses have to say, they also need to discern the credibility of that witness.
You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get this witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony?
So being a shitty witness makes her a great witness for the state. And it also gives the state the opportunity to be able to introduce one of the most powerful pieces of evidence. Her little visit to the crime scene. Twice. Once through the officer who saw her pull up, and then once again through her. And the main thing that makes this so potent is that the testimonies are the same, but with some very glaring differences.
Your testimony, officer, is that it appeared that this van, which had a clear view of her ex-husband's house, right?
I didn't even think, that's the house.
Yes. Your testimony is assuming to this jury that it was Wendy Adelson that was driving that car, right?
I'm sorry, say that last part again.
Your testimony, what you're suggesting to these jurors, is that that may have been Wendy Adelson in that maroon color in this vehicle, right?
Correct.
Yeah, and an officer was there.
I didn't see an officer, but I did see a car.
A law enforcement marked vehicle? Okay. Did you have any contact with the officer?
No.
Okay. And so your testimony was also that when the car came, the person didn't stop and ask you what's going on, right?
No.
I just thought, there's maybe some trees down or something.
The person didn't get out screaming, oh my God, that's my ex-husband's house, right?
And so I drive up Trescott and I see the tape and I was like,
No.
And you would agree with me that that may be considered a normal response to seeing law enforcement and crime scene and EMS and somebody that you had a relationship with, that's their house, right?
Quite possibly.
So the normal response would have at least been to inquire, correct?
I can't say what her normal response was because I don't know what her role exactly was.
Okay, well, let me ask you this. The car in question didn't stop, right?
No, sir.
Okay. Didn't stop to inquire to you as to what's going on, right?
No, sir.
Did you do anything after that to try to find out what was going on down that roadway?
No, I just assumed it was weather or maybe a tree fell.
Didn't get out of the car?
No, sir.
Didn't ask you any questions?
No, sir.
Okay. And pretty smoothly made a 3-point turn and drove away, right?
Correct.
I would have made like the kind of turn, like a K-turn thing.
And who do you think the jury finds to be a more credible witness? The police officer, who is just simply testifying to what he's already written in his report, or little Wendy Weasel, who has a vested interest in trying to appear innocent. Now, considering the fact that she had to be forced by subpoena to even testify, and additionally be given the assurance that her words would not be used against her. Let's consider what would have happened if she would have been arrested first. First off, I think the likelihood of her cooperating at all would have been virtually non-existent. I think the only way that she would have even entertained the idea would have been if she had been given some sweet deal. And I'm talking a massive sentence reduction at least. I'm sure that we can all agree that when Wendy gets sentenced, she shouldn't get any leniency. It would have been a huge miscarriage of justice had that have happened. We also have to consider the fact that there are over a half a dozen people who work together to commit this crime. One of the rights that criminals have is the right to a speedy trial. And there would have been no way that Leon County could have simultaneously tried 7 people, thus violating the rights of those charged, as they would have been left in jail waiting for their trials for a very long time. So as frustrating as this has been to watch this tick by one, that's really the only way to do it. Those are the main reasons why I believe Wendy has not been arrested yet, and why I believe she will be saved for last. I know there's been a lot of speculation that the reason why she hasn't been arrested yet is due to a lack of evidence against her. I don't believe this at all to be true.
Okay. But the specific nature of the email, you will agree, was in the event that there's some kind of mass arrest, because they don't know who's getting ready to go to jail next, right? I mean, they're not privy to the investigation any more than you are, right? Law enforcement investigations, they're secret. Sure. Okay. And their concern, would you agree that concern ultimately in the email was for the care of the children?
The concern was to make sure the children were under good care, but as their mother, I know they're always under good care with me.
Right, but
and there's no need for foster care.
The email contemplated you not being available to care for them.
That's not possible.
Because it's not possible for you to get arrested.
Correct, because I've done nothing wrong and I believe in our justice system.
Okay, well.
LOL. No one has inside information on what evidence is known until the trial. Even while the defendant is awaiting trial, there's motions filed under seal or even ex parte hearings ongoing that the public is not made aware of. Which leads me to my next point. While awaiting Donna's trial, which at the making of this video should be ongoing right now, some very interesting things have been happening. One of which maybe would have.
All right, 2 matters to briefly address before we bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Ms. Scalazzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise. Raise your right hand. Raise your right hand, please.
Oh my God.
Affirm the testimony.
Oh my God.
It will be the truth. Yes. You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what
she's just being signed in because fucking Descalzo is coming up. Oh, sorry.
Yes, Your Honor. The waiver is specific as to the counsel.
She's only being signed in
our client received
because she's waiving lawyer-client privilege for Descalzo to come in.
She's waiving, that's fine. I don't believe you can waive.
I got all excited for no reason. Okay, So they're swearing her in, and I'm like, it's Donna, it's Donna. Sorry, Victoria. Sorry. Always a bridesmaid. And I thought it was gonna be Donna.
Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that was discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Yes, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
You may not. One moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced at this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent.
Jackie
Please
Fulford is
check
wearing
with the
two different
jurors,
earrings.
Let them know that we will get started momentarily. Okay.
You have 5 minutes to decide. 5 minutes to decide. We want to go over all the testimony. We want to go over an entire week's worth of testimony. Donna, where have you been this whole trial? Have you not been sitting there listening to the evidence against you? She's wearing 2 different earrings. Yes, I'll back it up because that irritates the fuck out of me. It doesn't take much for me to get irritated by Jackie Horseface Fulford.
Accessed court early for you
Judge
to
Everett
address
is
any issues
pissed.
of witnesses or whether your client would testify.
I'm backing it up.
Yesterday when you
watch.
allowed us to
Pearl,
recess
gold.
early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there. Because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential.
Okay, you had no issue with a potential witness. The issue is, and it's been the same issue since this trial started, before this trial started, is you are not prepared. You are not prepared. Why in the hell? Why does it take 2 of you guys to go to the jail? And if you're at the jail, why are we not talking to Donna? Why isn't one of you figuring it out that the person that you just decided out of the blue that you want to testify is not going to testify? And why couldn't the other one go to Donna? Why couldn't you guys? This is the time. This is the time that we got out yesterday. 2:45. It's almost 2:45. 2:45. Hi, awake, Nina or Nini. 2:45 was when court got out yesterday. A full over 2 hours early. Okay. And you didn't have time. But what do you have to figure out? You're gonna ask her questions. American Psycho. This defense team couldn't spell cat if you spotted them the C and the T.
Is the response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at Sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
She's scared that Georgia is going to take little bodies and this to it, and then do this, and put her over her knee and do this. She's afraid. She just watched a lawyer get her ass handed to her on a platter by Georgia Kappelman. She knows. This guy's like, I'm going up because I don't fucking trust Donna as far as I can throw her. I think they are just hearing voices. Wouldn't it be hilarious if Zellman was like, Judge, I have been popping in and out of Jackie St. Germain's live, and she is so mean. Yesterday, just last night, she posts a picture of Fulford as a fucking ventriloquist doll on my lap. So we're just assuming that I have my hand up her ass, and she's just sitting there praising us, but in a way that seems really sarcastic. I can't take this. They're saying that she needs a bag of oats every time she goes up here. They're being really mean, and our feelings are super hurt by it. I do not look like that dinosaur from the show Dinosaurs. And I resent it. And Georgia is not the mama. Oh, yeah. Betsy, I did see your comment that Emily D. Baker said that Donna's probably not going to testify. Yeah, I'll make a poll. Guys. Come on. Why are you not doing this? Okay. All right. Poll has been created. Miss Fulford, do you need an oat break? See, this is what we're talking about, Judge. Nobody should be asking Horsey, I mean Mrs. Fulford, if she needs to take a break to munch some delicious oats. She has already eaten a whole bale of hay. She doesn't need oats as well. This is just rude and disrespectful. What happened? Sorry, Juicy Baby got sad. Look at Georgia standing there. I love her like crocodile hunter chic outfit that she's wearing today. It's everything. Look at her put her hands in her pockets. I live for Georgia. Georgia, I want Georgia to just lean into Donna and be like, you scared, old lady? You scared of this little backwoods Tallahassee hick? I thought I knew nothing. I thought I'm just up here doing Dateline for everybody. Is that why you're scared? Are you scared that you'll be able to answer your lawyer's questions perfectly well and not mine? Yes, Juicy Baby is upset. Okay, I'm sorry. Okay, obviously Donna is scared. As she should be. She's going to get eviscerated on the fucking stand if she goes up there. I'm for it. I'm here for it 100%. But, yeah, Juicy Baby bumped her head, but she's the absolute, hi Aries girl. She is the absolute sweetest. She literally, like, it's so funny because Hunter, like, cracks up every time because she'll come to me, like, full of crying, and I'm like, oh, you hurt yourself? Let me give you a hug. And I give her a hug, and she, like, just walks away fine. He's like, is that all it takes? I'm like, yes. Meanwhile, my boys were, like, so dramatic. Oh, when they hurt. Yeah, Georgia was literally, like, just catching frickin' Burmese pythons in the Everglades this weekend, and now she's in here to wrap them around frickin' Donna's neck. I can't. Can I just like to tell my side of the story, Judge, and I don't want to get cross-examined. What can we do? Can we come up with some new sort of rule that I could just tell my story and they don't get to ask me questions? Or at least can Sarah ask me questions? She seems to be the nicer one of the two. This family is cursed, and I don't know how to take care of it anymore. That's my favorite part of that. Of her little, yeah, Jackie Fulford needs to be sent to the glue factory. I don't know if anybody noticed, but on my short today, and I don't know even if it shows this, but it always asks you, like, for location, and I never fill that out because I'm like, it's just like a weird, part of the thing. But on here, I put glue factory. Doesn't even.
Did you
show
have
it
the
anywhere.
opportunity to speak to her on the telephone when you were away in New Jersey?
I don't know, not here. But this stuff is, like, different than normal. So, is it in the description? I put hashtag glue factory. Oh my God. Annie was so excited to be there. She's just excited to be here, folks. Oh, fucking glue factory. Do you know that I used to live, okay, story time. I grew up in Watkins Glen, New York. And do you know what's like 2 towns over from Watkins Glen, New York? Horseheads, New York. which is probably where Jackie Fulford was born. Oh my God. And they're now turning this 5 minutes into like 25 minutes. I'm going to make this feedback Fulford huge really quick. I can't. I cannot. I searched feed bag because obviously I wanted to make a picture of her with the feed bag. And they were like, all the pictures that I got was, this is insane. This is insane. Yeah, I live about an hour from Syracuse now. Okay. We're back. Make this a little bit smaller. Even though it doesn't deserve to be. Up. Yes. I know, Carol. It's mean in the nicest way possible. I could say much worse things about her. She's a terrible piece of shit. Oh, there we go. All these New Yorkers. Judge Everett's like, I'm gonna frickin', you know what? I'm just gonna go ahead and rule. Donna, you're guilty. Get the fuck back in jail. Go to prison right now. Yeah. Flop, 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 flop,
All right.
flop, flop.
You're entering the
Hi, Mike,
courtroom.
buddy. What have we decided? What has she decided? Why aren't they telling us anything? Selman's like, there's still people laughing behind us. The fact that Selman is crying.
Everyone can be seated.
I don't
Members
know.
of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Donna.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
Yes, I object.
No, Your Honor.
Defense 50 is admitted.
Thank you.
I don't know.
At this point in time, the defense would call Marisol Descalzo.
Lysol Descalzo. Okay, so this is the lady. Yeah, I was going to show you a picture of her, but hello, she's walking in. No, Horseface is pissed. Horseface is upset because Horseface wanted to go over the entire testimony. She wanted
Please
to
raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
I like this.
You
Oh,
may
she's
as
wearing the same shirt as Donna.
Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
Nobody
And
knows
Ms.
how to spell
Descalzo, can you tell us how
Marisol
you're
either.
employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of
hit
time
Donna when Donna said, "Oh my
ending
God," in court.
shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
And I want to direct your attention specific to October, the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Is Gila the only one?
Did that cause you to take any steps or actions to determine
Maybe
what
just
you needed
refresh
to
your
do.
feed.
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that,
Send her to Vietnam.
did you
Run,
have
Donna, run.
further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
It sounded like.
Mr. Rashbaum and
They were
I
gonna
spoke
see
to
if
her
they had to
further, and you know, she told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Liza
At
Minnelli
that point in
lied.
time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest.
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Miss Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
Did you advise Mrs. Adelson that if she buys a one-way ticket to Vietnam after being on a recorded jail line saying that she needs to flee to a non-extradition country, that a warrant would be issued for her arrest? Did you advise her of that?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor.
Cornbread, this is her lawyer when they were, when she first came to Leon County and she was mad that she was being put in solitary. And she said, "Oh my God," in court out loud.
Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended. Is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay.
So, I don't know if you know this, Brian, and anybody else. In the state of Florida, so when you're Baker acted, that means the hospital can hold you for up to 72 hours. And to be Baker acted, if somebody considers you a threat to either yourself or others, they can Baker act you, which is a non-voluntary psychiatric hold for up to 72 hours. But and I don't know if everybody knows this, but under the law, under the, the things of being Baker acted, they give you a choice that you can either 72 hours psychiatric hold, or you can go to Vietnam one way only, though. And that's the rules. So that's what happened here. She just chose option 2.
Would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay.
Bullshit.
Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay.
You could try.
You suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time?
Okay. They brought her in because they wanted to say that, and Donna even says on the phone, our lawyer told us to do this. Our lawyer told us to do this. And that's why they brought her in, because they wanted her to say, I told them, go on vacation. It'll be fun for you. It'll relax you. Go to the Four Seasons. Go to Charlie's Vietnamese villa.
Time that the
Enjoy
vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection. Your Honor calls for speculation.
Overall,
it doesn't.
Witnesses opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight,
as her attorney,
okay,
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second.
Vacation, all I ever wanted. Vacation, had to get away. Vacation, I was not trying to flee.
Specifically, though, about self-surrender. Would you expect that to change law enforcement stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
My 10-year-old.
Direct examination.
My 2-year-old could answer that.
Mr. Scalzo, prosecutor asked you about fleeing the jurisdiction.
Not just the jurisdiction.
My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
I think she just doesn't want to answer that question.
And the state also asked you about
Donna waved at Charlie.
fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Please let it be Donna.
Just a moment, Your Honor.
Vietnam one way or
Sarah
another.
Newhouse?
No, you're pronouncing Donna Adelson wrong. It's pronounced Donna Adelson. And she's sitting right next to you. Oh my God, that's all they have. I'm pretty sure. Who did they call? I wasn't even saying. Vacation, all I ever wanted. Vacation, had to get away. Me and Harvey just going to non-extradition places to have some peace. All right, I screenshot off of Daddy's Playhouse last night. Cat hair in my eye. Need to go.
Please come up to the witness stand. Raise your right hand now. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly.
No, sir.
You may examine.
Thank you, Your Honor. Good afternoon.
Here's what you missed. They asked Donna if she wanted to testify. And Jackie Fulford says, we haven't had time to even talk about that. And the judge says, you have literally 5 minutes. And Jackie's like, we have to go over all of the testimony. They have been up there for 6-7 days, and they did all this evidence against her. And obviously, Donna hasn't been paying attention. She hasn't even had her headphones on for half of the trial, so we need to tell her what's going on. And then we came back, and they put on Marisol Descalzo. The end.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Bear Brook Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things.
Maybe go for a walk in the woods and tell it to a kindly little frog. This is not what I pictured her face looking like, by the way.
Of that nature, and it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendy Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendy Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendy Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendy Adelson called her mother?
It is.
Okay. When Wendy Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markell had been shot?
What?
Yes.
Okay, real quick. This was a dumb choice. Do we recall Wendy's reaction saying, "Oh, they sounded surprised. That's good because I couldn't handle if they killed Dan," basically. I mean, we just watched that in that video that we just watched over lunch. Oh my God.
Did this upset her?
She
I
sounded
can't handle
shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
A shocker.
And
Wendy
did she
would say. Two in the pink.
did she make any statements that you could hear
I'll go away.
from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
Your Honor, at this point in time, I'd move into evidence Defense 71.
Any objection?
Can we watch the video? Please let it be the video.
Review this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it to the jury room.
I have something in my eye. I went to mirror. I don't know what it is. Like something, when you get like those like clear, just like fibers from, I don't know, but hell, straight from hell itself. This is a dumb idea. Because now they're going to say, did Wendy say that she was glad that her parents sounded surprised and said that they were capable of killing Dan pretty much? Yes, Carol.
If anyone needs to stretch their legs or use the restroom, please do it now.
All right. What are they introducing? Are they going to introduce the video? The video? Because I don't think that, and not only that, but right before she calls her parents, she goes, okay, so I don't really know what I'm going to tell them because I don't even know if Dan is dead. That's what she says to the victim advocate right before she calls her parents. I don't know what to tell them because I don't know if Dan is dead. What? I'm sorry. The fuck? Come again. What the fuck are you trying to say? You don't know what to tell them because why? Because the plan hasn't gone exactly as you guys had envisioned it to? Remember when Donna didn't call Annie the day of Dan's murder, but Annie said she did? And then they brought her back from the airport. And clearly spoke to her about what she was going to be testifying about. And George is like, so you talked to her on WhatsApp then? And she's like, yeah, totally. And she's like, WhatsApp didn't even exist for voice calling then.
Includes Wendy Adelson saying this is the worst day of my life before the call connects. And then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand they don't tend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
Mr. Zellman?
As I indicated to Ms. Dugan when Ms. Kaplan was watching it, I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back any jurors.
Did he just do this? You did a great job. No, I'm really, really proud of you. I am really, really proud of you. Yeah. Well, if he's not dead, then that's a game changer. Then I have to change. What else did she say? That she had to change her plans or something? Sorry. I've like trauma blocked a lot of that interview out because I literally must have watched it 700 times over when I was making my Wendy series, to the point where it was like genuinely playing in my head at night. But let me look. Get the F away from me, you freaking fly. I'll punch you right in your face. I opened this window because it's beautiful outside right now. Okay, so Sherry. They bring in Sarah, the victim advocate from Wendy's interview. Okay. And
if there are no other witnesses for the defense,
she's not an expert witness.
It is time for the decision to be made.
Donna,
I can tell the court that co-counsel and my client are deep in conversation concerning this.
I am capable of seeing that, Mr. Zellman. No narration is needed.
Donna, make a fucking decision. You were able to decide to kill Dan like that, and this you're hemming and hawing about? All right. I want to see exactly what she says. Right now I have it. I'm pretty sure we just watched it. I genuinely like block out.
Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
Please say yes.
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please
Come
rise.
You've
been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of it.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss, or have you been able to discuss with your attorneys, the two rights that the court has placed before you?
Yes, we've discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you are in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your
Had
choice?
a year, over a year. You were arrested 2 years ago, Donna. You've had 2 years to think about it. You had a full 24 hours since yesterday.
Judge, since I was handling the prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
Donna.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
The judge is being...
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
They gave her 5 more minutes, like 45 minutes ago. Okay. Okay, so this is what they say. They're very angry with him, right? Like, well, this isn't like their son, but he's the father of my kids. And this is a very, pardon my language, a fucked up situation. Okay, I'm gonna call my parents. Okay. I have no idea what to say because I don't even know that he's dead. And then I interject. And if I can't tell them for sure that he's dead, then we spent all this money for nothing. Mom, how's it going? It's me, Wendy. I need you to sit down because I have some tragic news to share with you. Are you sitting down? Is Dad there? Are you on speaker? Dan has been shot. Unfortunately, he's still alive. I'm sorry that I had to tell you this, but I wanted to let you know. What? Donna's response. What? What? Oh, and Mother, please call Charlie. Tell him so I do not have to tell him, because he will surely clap out loud. And the victim advocate is sitting right next to me. I'm fine. The boys are fine. Danny has been shot. All right. My kids are yelling at each other. Yeah, and then she literally says something like, okay, here we go. Is this it? Sorry, I'm just reading the closed captioning because... You need some water? Okay, hold on. Yeah, if he might make it, that's sort of a game changer. No, it's not. You are a terrible person. All right, let's go get you water. Hold on, I gotta get you some baby water. That's what she says. If he's still alive, I need to make different choices. And then realizing that she said that, she's like, I I want the boys to be with him, which is total bullshit because then, like, and literally, I don't know, 10 or 15 minutes later, they're talking about telling his parents, and she goes, don't they want to wait till it's definitive? Till it's definitive? What? Till he's totally dead? So you don't want his parents to even have the chance to go to the hospital to see him, but you want to take your tiny little babies to go see their dad in a state. They're back.
Can be seated. Zellman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion.
Please.
We are not finished with the colloquy quite yet.
I'm still not decided, Judge. My family is cursed.
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on.
Decide, you fucking murderer.
Mrs. Adelson, the question remains.
Come on.
As it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
Does Wheel of Fortune have music?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record.
Ms.
Kappelman, you indicated the state will not have rebuttal.
Didn't say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Donna's like, then I want a moment to confer. Why do they get a moment, but I only got 5 minutes an hour ago? Guys, I needed that material. I mean, I didn't, but I wanted it. She's regretting her decision already. I am going to punch this fly in its fly face. This is the ghost of Jackie Fulford messing with my life. Fly out the window. I'm going to open the window and a frickin' like hornet is going to fly in. It'll be the murder hornet, Wendy. Guys. I'm going to text Judy right now and just tell her to be like, Donna, this is the ghost of Denmark Hell. Testifying is your only way to save yourself. At the moment, yeah, no, she said at this moment, I don't feel like testifying. She thinks that she can change her mind. The jury's going to come back guilty, and then she's going to be like, hold on.
I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions.
He's regretting.
The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
Of course you haven't.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. And we'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We're thinking about
a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
we're thinking about maybe, come on, yeah, she's a frickin' wimp. Donna, I'm not mad, I'm just disappointed. She's gonna be like, I want to testify. Put me up there. Put me up there. But as soon as Georgia starts to cross me, I'm gonna be like, my earwax, my small ear canals, they completely clogged. I'm deaf. I'm deaf. And I don't know sign language. I can't answer, Judge. I can't read lips. Please. I guess if Georgia wants to write everything on a chalkboard and hold it up, I can blink once for yes and twice for no. You got something? Let me see. Ooh la la. A little candy? Yeah. I should have testified. I should have said it. I didn't do it. I made the banana bread. I didn't do it.
I didn't see a banana bread.
You know, the witch was making banana bread. You want to see the witch? She'll come up. Hold on.
Where is it?
Hold on. I'm going to be with Judy tonight at 8 o'clock. Hey, Harv. Why aren't we having a cross, guys, or a freaking rebuttal case? We called Charlie Adelson to the stand.
Ed, the witch. Where is the witch?
Hold on, they're not showing her yet. She's talking to her lawyers. Hold on. Yeah, rock, paper, scissors, Donna. Exactly. If I was not guilty of something and the state put on a full week's case against me, you better believe I'd be up there. Yay. I know. Put on a rebuttal. I want to hear. There's so much that we haven't heard about, guys. None of the new wires. I hope that Georgia says, no, we're going to put on a rebuttal.
Is there
The
another
judge.
witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions.
This book he's just leafing through is called Being a Criminal Defense Lawyer for Dummies. I saw the front page.
The state's indicated that they're objecting. If I could just have a moment.
Mama, I need a witch.
There's the witch. You see her? She knows Donna is the witch. What, baby?
What are you doing?
Everett could not be more over this. He's like, Georgia, can you please not? We don't want to do any more of this. Like, let's just let the jury. I mean, guys, do you? Okay.
Mama.
All right. I know. Yes.
Milky.
I'll give you milkies in a second. Hold on. Look at everybody. Say hi. No, no, no. They want to see your pretty smile face. Can you smile? Can you give heart hands?
No.
Can you do heart hands? No.
No.
Do you see the witch?
Yeah.
Where's the witch?
There.
Yeah, she's right there.
Milky.
Okay, hold on.
Milky.
Okay. Yes, Donna is Wilson in Castaway right now. She does not, I'm sorry, but she does not like this. I know, Christina. No, the defense has no idea what's going on. They're like, I think there's something. But guys, okay, so I know we all wanted to watch Donna. Whatever, that's fine. But, yes, broken wings. We get to arrest Wendy even faster. She regrets her decision.
Zalman, concerning the items, we do need to move on so a ruling can be made.
This is... Donna, are you sure you don't want to testify? Please. Jackie St. Germain needs more comedy fodder. Are you sure? She's going to be way nicer than you. I mean, Georgia, it's just going to be a temporary thing. You're going to be in prison forever already. I mean, you might as well go out on a bang, Donna. Come on. Come on. All right, here, Donna. This is what you can say when Georgia asks you a question. You just pull a Wendy and you say, I don't remember. I don't remember. I don't remember. I don't know. I love Dan. You know, too much of her testimony would open up other things for the state. And no people.
Yesterday, the state, or I'm sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar as well as the 2023 calendar. That is, I believe it's States 51. No.
Now, does it say anywhere in this calendar that Donna wanted to kill Dan? No? It's closed.
What's the question?
Why are they admitting the entirety of this this planner? Oh, for no reason? Great, thank you. Okay, so what I was saying, we get to arrest Wendy faster, guys. All right, this is not all bad. Wendy goes to prison sooner now, just that much sooner. Okay, tomorrow they will do closing statements. Actually, the defense will ask for another month and a half. But tomorrow they should do closing statements. And that means we will get a verdict tomorrow.
Councilman, concerning these items, what is the state's argument?
The state's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes.
Yep.
The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country.
Which
Contrary
she was.
to that, there are a ton of pages going back to January 9th of 2020
that she's selling
where my client lists those very same items to get prices to sell, to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes
Who was going to lay the foundation concerning the items that you wish to admit?
Not Donna.
Foundation's already been laid by the state, Your Honor.
No.
It was seized
I
by...
believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Donna won't.
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted. Not that she was...
Hold on. These are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information.
Donna's gonna jump up.
All we're seeking to admit are the pages from the 2023 calendar that list those additional items.
You've said that
List the
6
items that the
times.
state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages, and I prepared a copy with highlights to be able to present to the jury during
Oh my
closing.
God, you prepared something.
But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. So these are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit or do some additional research. But again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just one.
Hold on. There's got to be another person that we can call because none of our witnesses even made a dent in our case. We call Donna Adelson. We've subpoenaed her. Please, I would die. I would die. We'd like to have just a few moments to draft up a subpoena for Donna Adelson.
Open it.
You gotta twist it. There you go. And we would like to compel her to testify. We told her that she would be given use immunity.
The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, who's going to lay the
Again, is there any
foundation?
witness who will testify to these matters, or just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, that has been admitted so far in this trial, is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor, and for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
And Judge, the state has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct,
Yep.
Your Honor.
Jurors are fine to come in.
To be perfectly honest, Judge, we have not prepared for one single second of this trial, so the fact that it is over now is really kind of boggling our minds. Jackie Fulford's like, what the fuck are we gonna do? We've done nothing this whole entire trial. I thought this was gonna be a slam dunk for us.
Everyone can be seated. Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening.
Who gave Donna claw clip? I feel like that could be a weapon. Donna's regretting her decision, 100%. All right, so Donna's toast. Guys, it's a Wednesday. This is when we do grand jury hearings. Do you think there's
Everyone can be seated.
for Wendy?
Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, I did not drive down Trescott.
No, Your Honor.
I just drove down Trescott to the tape.
3.2,
Like
Statement of the Charge. Any requests or
like
changes?
a K-turn. Yeah, can we change those charges to not murder charges? That's the defense's.
Your Honor, the only request that I would make is that the name of my client and the names of the charges do not be in all caps.
Yes.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
Just laugh.
I will make that change. Let me make a note.
Okie dokie. That was Charlie's favorite. That was like the highlight of his year. Yep.
Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
Can we say that she's not accused? We'd like the word not to be put in front of accused, please.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
The defense doesn't know what that means, Judge. Could we have a year and a half to go back to law school and figure out what we should have done in this case? And poor parent. I think she just didn't want to go up against Georgia, Jules. I don't think. And Jules was Juicy's nickname. So her name's Juliana, and then we used to call her Jules, and then we would call her Julesy, and then it just changed to Juicy. And if you ask her what her name is, she says, "I'm Juicy Baby." Oh yeah. Yep. I think they only get a certain time for closing arguments. So the state isn't going to decide to arrest me. The state isn't going to decide to arrest me. I fucking hate that bit. I can't wait to put that clip sandwiched in between her getting taken to the ground over and over. The state isn't going to decide to arrest me. Get on the fucking ground. That's what's gonna happen. Yeah, Donna gets a 95 for delay tactics. Do you know if I compile every single day of this trial?
Your Honor, the defense would request the manslaughter lesser.
As the second degree, lesser, are you requesting that as well as category 1?
With the
Yeah.
Although it's a category 1, the lesser still carries the same penalty. So we're not requesting second degree.
Is the state requesting second degree as a category 1 lesser?
Yes, sir, we'd be requesting all lessers.
Well, all category 1 lessers will be given. Second paragraph will read in the introduction, first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful.
Okay.
However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful.
It is not. It does not even categorize as second degree murder at all because it was pre-planned. There is nothing that says that Donna was now just made this split decision. Donna was fighting for her life. It was self-defense. It was self-defense, guys. It was self-defense. Case closed. Donna's innocent. Free Donna. Hashtag free Donna.
I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform the indictment, we would request his full name, Your Honor.
Acceptable, sir.
Wendy has got a long way to go.
If you find Daniel Markel was killed by Donna Adelson,
Make it to the border of Mexico.
you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requesting.
All right.
Your Honor.
Of course, you always need a moment. What I was going to say, if I compiled the entire, all 8 days of this trial, just keeping out all of the sidebars and breaks, it would probably be a 2-hour long trial, by the way. And I should rewrite the words
Mr. Evans, Ms.
Baker
Kappelman.
Street to Baker Act.
No objection removed.
Just the definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers.
Oops.
Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser-included crime.
Donna will already be in prison. Well, I guess they'll probably have a month that maybe they could be in the same spot. What's wrong, Juicy Babe?
As to count 1, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
She wanted her food.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given.
I like how
The
he's
question of
killing.
premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation, that will be removed.
The poll was pretty close. 52 to 48% for yes. I'm disappointed, Donna.
All right, instruction 3.4.
Hello, ZYGT.
This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
Yes, sir.
Yeah, Donna knew she was done. Judge, it's too late for me to give you my daughter. I'll tell you anything you want to know. It was Wendy. She told me. She told me everything. Please let me out. I'll turn over Wendy right now. I'm gonna call her on a private line. I'm gonna say, Wendy, listen.
7.4, second-degree murder.
Talk to me as a lawyer who doesn't
Introduction
talk.
to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson.
100. She's scared. Scared. 100%.
Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life.
Maybe she will at her sentencing hearing. Maybe she'll stand up and be like, yeah, Anna. I know I was
As to the definitions,
I know I'm
believe
not.
act is repeated. Is there any objection to this stating an act
No,
has been
it's not
previously
me.
defined above?
Harvey.
I don't have a legal objection to that, Your Honor.
Mr. Evans?
It's George's classes. Who's this new guy? Who's this new guy? Who's this? If I'm ignorant, I should know. I'm sorry. Who's this guy sitting by Georgia?
The second definition, an
Please
act is eminently dangerous to another and demonstrating a depraved mind. That
Oh,
must
I
be
can't
given.
wait for her clothes. Yeah, clothes.
In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legal.
Okay. So can I just say something that's probably not true, but I would like it to be? So there's some guy sitting at the prosecution table. Where's Sarah? Could Sarah be in the courtroom next door, starting the grand jury trial indictment for Wendy? Please let that be true. Please let that be
Adequate
true.
provocation, that will be removed.
Guys, would you not piss your pants if Judy and I brought you breaking news today?
The next lesser, 7.7 manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on?
Jackie's like, all right. Or Donna's like, all right, Jackie. Listen, I'll give you $1 million right now. Pretend you're me. Switch spots with me. Put on this cardigan. I'll put on that oversized suit. And we'll just switch spots. You can go to prison. You can get out. You're a judge. You're a judge. This family is cursed. That would be so fun. Would that not be the most fun? Would that not be a fun way to end the day? I mean, where's Sarah, though, guys? Where's Sarah? Where's Sarah? Where's Sarah? Where's Sarah? Where's Sarah?
Well,
Where's Sarah? Where's Sarah, though? Where's Sarah? Why wouldn't Sarah be here right now? Why wouldn't Sarah be here right now reading the jury instructions? Where's Sarah, guys? Where's Sarah?
A
Where's
and B
Sarah?
will be split by an or.
I'm here to understand. Maybe Sarah is
Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markell, or
can't handle it.
Donna Adelson intentionally procured an act that caused the death of Daniel Markell.
She did. Yep. I am. Sarah right now is saying, I have the testimony of Wendy Adelson. She claims that she didn't drive down Truscott, but then says, I drove down Truscott.
Right.
He is,
Concerning the State
I love
versus
him.
Spencer
He's a little.
italic, that will be
They
removed.
have the closing statement done, I
And
think.
my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Kell was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
Wendy's
And
leaving
the defendant agree with that concession.
on a midnight train to
Very well.
Georgia.
Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead.
Wait, pretzels? Delicious. That she's going back to find her guilty state of mind. Wendy's leaving on that midnight train to Georgia. Georgia, careful, man. God, guys, I will literally.
Okay, Judge.
Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
I want to
Please discuss
testify.
it with them now.
Thank you.
I want to testify, Judge. I made a mistake. I didn't know what I was deciding before. I told you that in this moment I didn't want to, but in this moment I do. I changed my mind, Judge. The people laughing at me were too much. I sat here and I watched what Georgia did to that lawyer. I'm not a lawyer, Judge. Wendy's the lawyer. I'm just a domestic coordinator. Leave me alone. Yes, she does. This fly is really trying my very luck. I can't. If Wendy freaking your days are numbered. If Wendy gets arrested, guys, you will see me in here with a freaking confetti cannon shooting it off. Okay, so hey you, if you're on the witness list, you have to be prepared to testify. Whether you are called or not is kind of
Ms. Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that.
You are giving your consent to this.
I am.
Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm. That violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
And I'd like to solve the puzzle.
In order to convict of manslaughter by act,
Jamaica.
that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The
We
definition
make it out
of
this month
procure will be given,
without her being in jail. Obviously.
and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested.
I'd like to buy an eye. Life in prison. Oh, thank you, thank you. I won, Vanna. You're lovely. You're lovely. I have that same dress, you know. I have it in blue. You can bury me in the dress that I bought.
As to the first paragraph where it says attempted homicide cases.
We're not measuring this for the completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for
Correct.
the completed offenses.
I believe that instruction must be given for first-degree premeditated murder, and all references to attempts of any other sort will be removed.
You're guilty.
The state must prove the defendant intended that the killing of Daniel Markell occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markell.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
Yeah, you have to intend the act, but you don't have to intend to kill him.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor.
I run the schedules and activities for my jail daughter, 37-year-old Brina Bernhardt, and my other jail daughter, Patricia Bird. I just put it on the screen. It was 8.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not
Go back and
inviting error?
That's fine.
I rarely say go back and watch stuff. Go back and watch that. Georgia was on.
So you can contact me on that, Judge, and I'll let you know hopefully later this evening.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as the second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I excuse that, move down the principles already connects with that. So I ask yes, sir. No, there's no evidence that the defendant in this case actually possessed the firearm. So
No, the defense rested.
It will be removed.
That's it. That's it.
3.5 sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit.
Nope.
A crime, the defendant is a principal and
Mickey,
must be
eat your wood.
treated as if she had done all things the person who was promised or received the money did if the state proved beyond a reasonable doubt.
We have the funniest chat.
Then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion that says crime or attempt, the crime that the state is requesting, is that first-degree murder?
Yes.
Yes, sir, but I don't believe it. I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime.
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
No, she could have worn a sequin ball gown.
I think this crime is the appropriate one given the standard instruction.
I'm going to look at the standard briefly, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, Your Honor.
I would ask that the individuals, Secretary Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and or other persons.
Yeah.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal instruction.
3.5 sub B, element 3.
Yes, sir. But what I'm saying, for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, but we'll read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
just
this
doing away
pity.
with power.
Charlie got rid of his sex toys.
Yeah,
Donna's team
yeah.
could have used them to get her off.
And Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
By my reading, this is the new instruction.
This is the straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All 4.
Charge her with all the counts. Yeah. Let me tell you something, Lady Locke. If you would have told me at the end of Charlie's trial that, but wait, there's more, you will soon see 2 lawyers who will make Rashbaum look like a genius, I would have never believed you. Never believed you. You know, Tracy Flyer.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanawa, and or other persons to cause the first-degree murder to be committed, either by them or one of them or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanawa and or other persons. So I think it could be.
You're just requesting an and or between the names.
Yes.
No, the state of Florida does not play.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
He has heartburn.
Going back to the indictment, these are the individuals that are within the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And or is not going to make a difference.
You could put simply or. So and or, my understanding of and or are, it can include, basically, if you put something or, it means this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanawa or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine McBanawa or other persons.
Thank you for joining, Okie Danny, and thank you for gifting some memberships. And the judge did not just say conjunction was your function.
It is not necessary that the agreement.
A quick Google search.
Conspiracy.
Instead of Googling what's the difference between extortion and blackmail, if we would have Googled back in 2013, 2014, what would constitute first-degree murder? Do you have to be there pulling the trigger in Florida? Because in Florida, you just have to have anything to do with it, and you will be charged as the trigger man is.
Combination.
Yep, American Psycho.
Or confederation.
She's not still in her cans of tuna tonight.
to commit first-degree murder be expressed in any particular words or that words pass between the conspirators.
Yes. At least.
And lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense,
Donna's tuned out.
I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
Donna's playing tic-tac-toe by herself, guys. You know you're in a bad state.
We agree, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanois, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes, sir.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanois or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All four.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanois or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation.
Thank you, Sherry. That's so sweet of you, and I really appreciate that.
Go ahead.
I think the only area principle doesn't apply is for
I barely know what I'm doing, but I do it with confidence.
Do you wish for me to move then the two principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they have previously been defined. Or do we need to?
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the two instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter whether it can be argued that someone is a principal and solicited.
Thank you.
For now, I will just move the two instructions to the end of the counts.
If there are any counts that just needs to be clearly stated that conspiracy it does not apply to the conspiracy theory. I think we're all in agreement on.
I can add it, but ultimately no instruction can be argued as to the defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
Are they going to read the part about the consciousness of guilt with her fleeing? They have to consider that as a consciousness of
No,
guilt?
just add at the bottom the principal theory. Or actually, this instruction does not apply to count 2. And I will do that for both principal instructions. All right, moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
The basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
I am working on my Spotify, or not Spotify, Shopify. All right.
It's probably number 10's the only one we're not requesting. So 6,
And yes,
7,
Judy and I
8,
tonight at 8
9.
o'clock. If I know what I'm doing, you'll be able to
Defense
see us
have
on
any
both.
argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion.
No, I need to look on Amazon. I was going to do that.
However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you. Would you like to?
Yes.
Copy to the defense. Sorry about the typo in the title. And the certificate of service. It's all on Mr. Evans.
I want like the keyboard.
Right,
to look
as
like
to
a
the
typewriter.
requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
Just one.
He doesn't know what their position is because they don't know where they are. I'm going to draw you a carrot. Feed to your little fun. Yeah. Yeah, but I am working on a Shopify
I have an objection to
account.
the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at Sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Mr. Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
I think you're hearing Everett's keyboard.
Your Honor, it has just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested?
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
So, it's fine, Your Honor. So we're, for the record, as I understand it, of the bracketed languages under accomplices and informants,
who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right, yes, sir.
Yeah, that's not me typing, that's Judge Everett.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talk to lawyer. Is either party requesting this?
Yes, Your Honor.
That will be given. And be given all cases. You may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
No, Your Honor.
Rules for deliberation.
Sorry. Yes, Carol, that's right. The state will go, the defense will go,
Standard
and then the
instruction,
state
this will
will
be
end.
given. Does either party wish to be heard?
No, sir.
No, Your Honor.
Cautionary instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
Single defendant, multiple counts. Does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count 1, we the jury finds as follows as to count 1 of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser included offense of second-degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option, since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is to raise?
The only thing I would suggest, if we leave them involved, it makes it clearer for the jury to differentiate between each of the accounts, but I don't have any real strong feelings, but I see why they would be involved.
So you are requesting for it to remain the same or to not be listed?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we the jury finds as follows as the count 2 of the indictment, conspiracy to commit murder. Check, only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
I think the same reason why I'm asking for the names of the charges to be in regular caps, not all caps, throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's, to me, when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, we'll grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
Yes, Your Honor, for count 3 that you move it off page 16 to the top page 17.
I don't think my
I've been making several edits, so my pages aren't the same, but
don't worry, I'll get kicked out.
it will flow to where it's not being broken up between pages.
That'll fly home.
We're at closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
We don't know.
How much time is each party
Not
anticipating
Sarah.
for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
I love Georgia so much.
Submitting the case to jury. Just with the time. Nothing else.
I would not be able
Any
to
objection
control
or
myself
request?
Georgia.
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
I'll bet $50 that the defense comes in tomorrow and says Donna wants.
Judge on the exhibits, I think.
A demonstrative is not admitted, so yes, I would agree. It is not to go back into the jury room.
Delman comes in
Ms.
tomorrow
Dugan and I
and Donna
spoke
wants to.
earlier during the trial about going through especially
haven't missed
73 and
much.
73 and make sure it complies
The
with
co-
court's
the trial
rules,
is
so we'll
over.
do that before they're sent back.
Closing tomorrow.
All right,
Donna's
well,
guilty
leave it
tomorrow.
then. Photographic
Sarah.
discs, jump drives.
Is she making sure Wendy
Reports.
is getting indicted right now with grand jury?
And document. Exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing.
No Charlie, no Donna, no Rashi, no
The
Wendy.
final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
They're gonna go to the back just for funsies, and then they're all gonna look at each other and be like,
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific, principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
Right.
I don't.
Once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
Donna got arrested, then said Donna got arrested, then says she got molested. Donna was extorted, but she didn't report it. Her back hurts, where's her sleep number bed? She's not suicidal, but if she gets out, she might be dead. Living in jail is no four seasons. She needs to get out, has lots of reasons. Ear canal so small she cannot hear. Rampant and solitary, but living in fear. Gets twisted. twisted behind her back. They said she's a murderer and that's why they attack. From a penthouse in Miami to shackles in the court, lack of sleep is sure to cut her life short. Where's her band-aid? She's gushing blood. Waiting 8 hours will surely cause a flood. Where's Charlie? Where's Rashi? Where's Harvey? Where's Wendy? Needs to get to Vietnam, doesn't care if it's Spain. Living in jail is no Four Seasons, but she needs to get out, has lots of reasons. Breathing is labored, is it so loud? Lawyers can't hear her, inmates point her out in a crowd. Like a miracle when on the stand, her ailments disappear like they're just on demand. Tries so hard to cry but can't squeeze out one tear. Living in solitary but living in fear. She's gotta get out of jail, it's no Four Seasons. Please let her out, she's got lots of reasons. Her poor arms tingle, her back is tight. Can't sleep on this mattress, it's just not right. Nothing in the world that money can't buy. Wish I could order some tears so they'd see me cry. Sarah and Georgia put Charlie away. No, they're coming for me, but in jail I can't stay. I fled to Nam cause there's no extradition, but I can't stay in jail because there's no nutrition. Why, oh why doesn't anyone care? I gained so much weight and I can't do my hair. Living in jail is no Four Seasons. Gotta get out, I have lots of reasons. Just let me go home, Harvey's already here. Got a bottle of pills, let's just go to sleep, dear. Living in jail is no longer fun. I've got to get out, believe me, I'm done.
All right, guys. Love you. See you tonight at 8 o'clock. Bye.